He's back, y'all may be seated. Welcome back, ladies and gentlemen. As you may have noticed, I have waived the appearance of the attorneys, and they were allowed to waive the appearance of their clients because I only have one question for you. Were you able to follow the court's instructions that there were no issues overnight? Very good. You may now return to your jury room to continue your deliberations. Thank you.
All rise for the jury.
Jury's left, y'all may be seated. Court will be in recess until such time we have a question or a verdict.
About this, let's bring in Franz Borchardt and Casey early. And so with respect to the TikToking juror, Franz, she went on TikTok and announced, according to the Adelson motion, that she was going to be a juror in this case. And then she posted after the verdict. So announcement, is that enough to tip the scales in Donna's direction?
Not even in the least. It doesn't look like good optics, but ultimately, hey, I'm going to be a juror, and she's not told by anybody not to make the post. She doesn't make any post during the actual trial, and then after the trial, she makes a post. I don't think that tips the scales at all. And candidly, that's the world we live in now in 2025, where jurors do that kind of stuff. We saw that in the Karen Reed trial. It's not going to tip the scales. It's not going to get her a new trial.
Appreciate it, Franz. Let's take a listen to some more of what that juror said. This is the foreperson as well, so let's make that clear. Here we go.
I also had a lot of people asking if my mind was made up before we deliberated. No, no. I stayed neutral through the end of the trial, just like we're supposed to. You know, everyone's presumed innocent until proven guilty. You know, I kept my mind open and I took notes on everything, you know, from when both the prosecutor and the defense were arguing their points. I took notes on everything. A lot of people seemed really focused on my age, which is very strange to me. We had a super balanced jury, like a big age range. I was not the youngest one on the jury. And once again, if we're looking at the jury requirements in the state of Florida, you only have to be 18 at minimum. So, I mean, like, if you don't like that rule, whatever.
Okay, so with respect to her, Casey, do you think that the judge is going to allow the defense to inquire into her social media postings? That's what they want. They want to question her.
Yeah, I don't believe, unless I hear something compelling, but at the same time, I always say the voir dire process is the most important process of a jury trial. So if the defense didn't ask those questions and vet the jury properly, then they can't come back on the back end and say, well, they said this. Well, did you ask? Did you inquire? And did you raise a motion to strike for cause or use one of your preemptive read challenges? Like, if you didn't do that, then it weakens your challenge. But let me say this, kudos to the defense attorney. That was a well-written motion. After I read it, I started to forget about the overwhelming evidence against Donna in her trial. I mean, there were several points, but I really enjoyed reading the legal analysis. But the one thing that stuck out to me was denying access to the record. Because if, in fact, objections were raised and it was sustained without the defense at least alerting the court rather about what their basis was, then that is a problem for concern because everyone is entitled to a fair jury and a trial. So I think that would be their greatest argument. But otherwise, evidence is overwhelming, even if she gets another trial.
Great points, Casey. Franz, let me ask you about Juror 5. So another juror, this juror, male juror, he appeared on the podcast Surviving the Survivor that Joel Waldman does. And in the appearance, he talked about how he considered Donna Adelson's reactions to the evidence and the testimony that were coming in at the trial. We know she didn't testify. She was not on the witness stand. But then he subsequently made a statement that he obviously did not consider her reactions during the deliberations, said they're not evidence. And the defense is raising this as an issue, saying that, look, the court gave instructions, numerous admonitions to Mama Donna during the trial not to show any emotion. She was prohibited from doing that. This attorney thinks there's a question of whether the jurors held it against her. What do you think, Franz?
You strike me as a little bit of a rock and roll kind of gal, Julie.
Oh, yeah.
And there's a song by Bon Jovi that I celebrate on a daily basis called Living on a Prayer.
Great
and that is what I feel like I'm listening to. Now, look, the defense, as Casey has said, the defense is doing the right job. They're raising the issues. The problem is, again, this juror was very honest. I did look, but I didn't use that as my basis. I'm paraphrasing. I did look. That's human. It's human to look over and be like, man, she doesn't look like she's showing a lot of emotions. However, when that juror said, but I didn't hold it against her, that's going to cleanse that situation. Now, again, as Casey is brilliant, again, you got a voir dire on this. My client's going to sit over here during this trial, and I've advised her to sit like a robot and to not show emotions. And You know, and so if they didn't do that, it's going to be problematic for the defense.
Really great points from you both. Franz Borghardt, Casey Early, thank you both so much. I'm going to go play Living on a Prayer. You got me in the mood for some music, Franz. Thank you for that. We'll do it during the break and get some more coffee. We'll see you both back here on Opening Statements soon. And this is where we're headed next, friends. A live look at the courtroom in Florida, the pregnant mistress murder trial on the other side.
Medicare Part C is sometimes known as a Medicare Advantage plan. If you have Medicare Parts A and B and have been diagnosed with a qualifying chronic condition, there are 3 things you should do. 1, call the number on your screen. 2, give the licensed insurance agent your zip code. 3, see what Part C plans with benefits are available to you. 1, 2, 3. It's that easy. You may be eligible for a special type of Medicare Advantage plan called a Chronic Condition Special Needs Plan. Or C-SNP. These plans are designed for people with chronic conditions like diabetes and cardiovascular disorders. If you're enrolled in Medicare Part A and Part B and have been diagnosed with a qualifying chronic condition, you may be eligible to enroll in a C-SNP. But you won't know unless you, 1, call the number on your screen now, 2, give the licensed insurance agent your zip code, 3, see what C-SNPs are available to you. 1, 2, 3. It's that easy. Chronic condition special needs plans include all original Medicare benefits and can provide additional coverage specific to treating your chronic condition. Plus, you may be able to get other benefits not found in original Medicare.
Welcome to our first hour of Court TV Live. I'm Julie Grant. We're in Florida for the pregnant mistress murder trial. The defendant is Jose Soto Escalera, and he's being accused of murdering his mistress, 23-year-old Tanya Wise. Now, Tanya was pregnant at the time with his baby. She was 8.5 months along. Little baby boy named Josiah was also killed in this event. His defense is that he didn't do this, that it must have been someone else that she was involved with. This is a capital case as well. Here's a live look at the courtroom and the defendant. This is day number 3 of the case. What will it bring? We're about to find out any minute now. While we wait, let's look at the very best moments from Tuesday.
Bradley and Tanya lived at Tanya's mother's house.
Yes, ma'am, briefly.
Okay, and that Bradley was kicked out of Tanya's mother's house in March of 2018 because Bradley was violent with Tanya.
Yes.
And you learned that Bradley was possibly one of the fathers, correct?
Yes, ma'am.
You also learned that there was another potential father of the baby by the name of Mark Burke, correct?
Yes, ma'am.
And you learned through the course of your investigation that Mark Burke actually had a turbulent relationship with Miss Wise. Is that correct?
As I recall, yes, ma'am.
And that he had actually abused her and was arrested, correct?
I don't recall if he was arrested for abuse.
In the course of your investigation, you learned that Mark Burke had an active arrest warrant at the date of the murder for a fraud case. Is that correct?
Yes, ma'am.
And that his co-defendant in that case was actually Tanya Wise?
Yes, ma'am.
Okay. And that Miss Wise was afraid of him because of that case. Is that correct?
Well, there had been people that had said that, but she had had numerous contacts with him after he had an active warrant, and she never turned him in and met with him on a regular basis, so I didn't know how afraid of him she was.
Okay, and when was the last time she had seen Mark Burke, to your knowledge?
I believe when I interviewed Mr. Burke, he said it was the week of her disappearance, and she had performed oral sex on him in his car.
During the course of your investigation, you got a DNA sample from Bradley Rodriguez Jr., is that correct?
Yes, ma'am.
And you got a sample of DNA from Giovanni Alvarado, correct?
I believe so, yes, ma'am.
And you got a DNA sample from Mark Burke, correct?
Yes, ma'am.
And did you get a DNA sample from Jared Christie, too?
I don't recall.
Okay, you don't remember if you got that one?
No, ma'am.
Were you able to get a standard DNA profile for each of those individuals we just listed?
Yes, I was.
All right, and then did you do a comparison to the previously referenced standard of Josiah Wise, the baby, and the victim, Tanya Wise, to see if any of those individuals could be the father of Josiah Wise?
Yes, I did.
Okay, and what were the results of that analysis?
So the DNA profiles from the child, baby Wise, and the mother, Tanya Wise, were compared with that with these alleged fathers, and these individuals are not consistent with having the DNA profile of that required to be the child's biological father. So the DNA profiles from the child, baby Wise, and the mother, Tanya Wise, were compared with that of the alleged father, Jose Soto Escalera. The DNA profile from Jose Soto Escalera is consistent with that required of the child's biological father. The carpet tested positive chemically, indicating the presence of blood. The DNA profile obtained from the carpet was consistent with being a mixture of a major and a minor component. The female DNA profile obtained from the major component of this mixture matches the DNA profile obtained from the blood standard from Tanya Wise at all 21 locations. No comparisons are possible to the minor component of the mixture profile due to insufficient DNA quantity and/or quality.
All right, you are all caught up on what happened on day number 2, and the lawyers are still getting ready. The judge has not brought the jury in yet, so it gives us some time to talk and unpack this case with our legal analyst guest. It's always a great day here at Court TV, and we have attorney Holly Waltman with us. Holly has served as a prosecutor. She's also a practicing criminal defense attorney now in the private sector. All right, so let's look at the case from both sides, Holly. Let's start with the prosecution side. Capital case, as you know. How confident would you be if this case was yours?
Well, you never want to walk in confident, right? With the burden comes the opportunity and the privilege to go first in this proceeding. However, defense hasn't even presented anything yet. So I am never confident until the verdict is read.
Yeah. Okay, how about from the defense side? There's a lot of, let's just be honest, there are a lot of very bad facts against this guy, but as you know, nothing's a slam dunk. We know there's a DNA of many people on the victim's body, and the defense is really embracing that. They're putting forward this story of she had contact with different people, she was in violent relationships, he wasn't the violent guy is what they're saying. How viable of a defense do you think that is?
So it's going to rely on how the presentation of the state's case goes, right? This is still a circumstantial case. There are still big puzzle pieces, if you will, that are missing from a confession, from a murder weapon. There are things that are not directly here that will allow the defense to have a little bit of space to try and develop their theory of the case.
Sure. You mentioned murder weapon. I think that's something we really haven't discussed yet. Never been located, don't really know what it is. The ME didn't give an opinion on that, but we know this is a brutal death that Tanya Wise suffered. If you're defense counsel, how big of a deal do you make about the lack of the weapon being found?
You can make a big deal of the lack of the weapon. I don't think that brings us to a win at the end of this. However, I think you use it as a tool to discredit what the state has already presented, right? They have the conversation between this defendant and a previous coworker about trying to obtain a firearm. So if this man is the person that plotted and executed these two individuals, he didn't do it the way that he had planned. And so I would use the absence of a knife or a weapon to show that his plan wasn't in line with how this actually happened.
Right. And there's a look at Jose Soto Escalera here, and a lot of people have been talking, Holly, about his wedding band. Sometimes it's on, sometimes it's off. It's off today, as we can see. Would you talk to us a little bit about those things that you discuss with your client when you're going into a homicide case like this one? Optics, we know, matter. Jurors notice every little thing. What do you think about that, the ring? What would you say to him?
You know, one of the things that I think is important to discuss with your client is the consistency of your presentation. From the moment that these jurors laid eyes on him, heard the indictment or the information being read out loud, judgment begins then. Even though they are instructed not to cast judgment or apply any sort of investigative skills to this until the end of evidence has been closed, we're humans. Jurors are humans, and they're gonna do that. This could be something as simple as just a message to his wife, like, I'm seeing you, I love you, I miss you. It could be just he forgot and they were rushed to court today. I would suggest that it be consistent throughout the trial. That would be my preference, and I'm sure his counsel is hopefully advising him of that.
Right, yeah, either go all in, you know, one way or not. If you're gonna wear the band, then wear it every day. Or
yeah, and don't give them something to be distracted with, right?
Yeah.
Let them look and focus on the evidence coming from the witness stand rather than your appearance, how it's changing day by day.
Definitely. You know, in talking to jurors after trials, I'm sure you've had this, it's remarkable, isn't it, what they notice, and what they fixate on.
And what they have questions about, things that I, as a practicing attorney, hadn't even contemplated. They're at the end of the trial asking the questions back to me that I never considered, right? There's something to be said about sitting with a case, preparing a case for trial, both on the defense or the prosecution side. You have it so long and you're so intimately involved with it that you sometimes can miss the bigger picture that jurors see during a trial.
Yeah, definitely, Holly. Thank you so much for the discussion. We're getting word that the jury is being called for. So let's do this. We'll hit a quick break. Don't go anywhere. Court TV Live continues after this break, and we're going to see the start of testimony in day number 3 for Jose Soto Escalera in the pregnant mistress murder trial. 8.5 months pregnant, a young mother found brutally murdered.
To lose a child, there's no words for it.
Now, the victim's boyfriend, a married father of 4, is
charged for the murder of his alleged mistress and her unborn child.
That's one of the things that struck me. He was not remorseful.
From the first gavel to the final verdict, Court TV takes you inside the South Florida courtroom
for this tragic death penalty case.
The pregnant mistress murder trial. Live coverage today, only on Court TV.
Welcome back to Court TV Live. I'm Julie Grant. Let's get you back into the courtroom in Florida in just a moment for the pregnant mistress murder trial. In the meantime, I want to let you know we got the verdict clock up on the screen. The trial over the death of beautiful 4-year-old child Suni Bell. This is day 2 of the verdict watch. We're at 8 hours, 33 minutes and counting. She was shot and killed back in 2021 in the backseat of her family's car. 5 defendants being accused in this. Police say 40 shots in total hit that vehicle. Can you imagine? And that little angel was taken. We're going to have updates throughout the day. We'll let you know any questions coming from that courtroom. We'll bring them to you live. Meantime, let's go into the courtroom in Florida. Apparently, the defense attorneys want to introduce a video of defendant Jose Soto Escalera with his nephew. Let's go in.
No interpreter was provided. The jurors in Miami, half of them spoke English, half of them spoke Spanish. Reversible error not to have an expert come in and just leave that to the jury.
So she's doing that right now.
All right. So my suggestion would be, since the ones who come to me are not in order, that we take theirs and just photocopy them 12 times and then give them back to them. But I need one. I'll need one to read some things to them.
You'll need another copy.
I need a copy sent to me.
Do you want?
And it really can just be the standard ones, because there's nothing.
I'll forward it once I get it.
And then my suggestion is, rather than giving them 11 new copies that are in a different order than what they have,
Just have available
taking that one,
copy.
photocopying it. Christine, can you do it? I hate me right now. Chris went along with your suggestion. And I just tell Christine, I said, I'm afraid of her. It means I'll be with her.
People are afraid of it.
Next week, we have Wednesday, big docket, big sentencing, and the long motion for severance and executive. So I don't think we can take any cases next week. We'd have to tell the jury that they'd have to be here Tuesday, skip Wednesday, and come back Thursday and Friday, which I think they do. What's that? Oh, yes, and Tuesday's a holiday. So we only have 2 days left. I just want to get on with my life. Yeah, but there's nothing we can do. No control. No control. Well, I can help it in yeah.
You're sending to your email, right, James?
What?
Are you sending to your email? Can you forward you instructions, or do you want them printed?
What did you say? You need my email?
No, I didn't know if you had it up or not.
I'm looking for it. I'm trying to see if I can
Okay,
find it.
or do you want me to just print it over?
You have them? Yeah, all I need is,
proceed to?
That's
Yeah,
the
just
text.
in case.
I mean, that's the office, that's the cell phone. Get rid of that one completely. So if you need me in the office, myself.
Your Honor, may the family come in?
That's a open courtroom.
Thank you.
All right, well, one of their initial questions is they all want their own copy of the jury instructions. So what I suggest is taking the copy that they have, since it's in order, and having Christina photocopy 11 other copies, so they'll each have their own. Now, their 3 instructions are as follows. 1, on each count.
I mean, their questions are.
The questions. On each count, does it have to be unanimous on the degree of guilty? Example, if 11 people say first-degree murder and 1 person says second-degree murder, does that mean they get charged with second-degree murder? Question 2, and I guess they're talking about the other charges. Question 2, if half the people are saying guilty on 1 count, but the other half are saying not guilty, does that make that a mistrial or not guilty on that count? And 3, related to 2 by an arrow, if we even have 1 juror disagree on a guilty or not guilty charge, does this cause a mistrial for the entire case or specific charge in which we disagree? My initial response to this after speaking with my staff attorneys, obviously question 1, I would just reread returning a verdict. It should be the highest, it has to be unanimous. That's standard instruction. I'll reread them that it has to be unanimous, that all must agree on the charge, and it must be for the highest charge that you all agree on. And if you don't agree on anything, then of course it's not guilty, which is in the standard instruction.
I disagree.
Regarding question 2.
Your Honor, just a correction, if they don't agree on anything, is it hung, not
Oh,
guilty?
it's a hung, right.
Right, okay.
Or they can find them not guilty.
Correct.
Question 2, regarding if half are saying guilty and the other half are saying not guilty, is that a mistrial or not guilty on that count, or is it the entire case, which number 3 and number 2 are really the same question. So if they can't agree, and it creates I'll read them, I'm going to read them an Allen charge too before I send them back. And if they cannot agree, I'm going to explain to them that any non-unanimous finding on any 1 count will not affect the findings of a unanimous count, and that if a mistrial is granted, it would only be for the charges in which there was no agreement.
I agree, Judge. I think
That's the law.
Judge, my one concern is I believe it's too early for an Allen charge. I believe it's premature at this stage.
They've been deliberating for almost 8 hours.
Judge, 8 hours in the scheme of things.
They don't agree. They're obviously split on some of these counts that they don't, and then apparently there's a difference of opinion whether it's first or second degree murder. But they'll work something out. But they seems to be pretty deadlocked when half the jury says one thing and half the jury says another. Do you all not? What's the consensus on reading the Allen charge now? Because I'm not married to that idea. I could wait.
Judge, I think it's premature.
Okay.
This could just be a question that they have right now as they're voting with each other. We don't know what stage they're at.
I mean, I initially talked about waiting anyway, like I said, so I'll wait before I do the Allen charge, but I will instruct the others as to how I explained it. If you unanimously agree if you unanimously agree on 1 count, and you cannot eventually agree unanimously to the other count, the unanimous count is not affected. And if 1 or more jurors can't agree and a mistrial occurs, it would not affect the counts in which unanimous agreement was reached.
That's fine, Judge. Can you write it out and then say it so that we can hear it?
That's what I just said.
Is that how it's written down?
That's how
Could you
it's
do
scribbled
that, Judge,
down.
please, if you don't mind?
So if you unanimously agree to 1 count and cannot eventually agree unanimously to another count, the unanimous count is not affected. If the jurors are unable to agree on any counts, any of the counts, any unanimous count will not be affected if a mistrial is granted.
It's really convoluted.
Well, that's what it is. I mean, it is convoluted, but
Judge, maybe make it short to say, like, the inability to reach a decision on 1 count will not affect whatever verdicts you find on any counts.
That's not a verdict.
Or whatever decisions you reach on any.
They don't want to know any decision. They want to know if they hang on a count, does it affect an account they unanimously agreed on? And I'm gonna tell them no.
Okay.
I'll explain it like that. Okay?
Okay.
Anything else?
Judge, I think it's fair. I think you could, if you could add, if they have any count or any defendant, does that make sense? Like, you're reading them
Any
the other
counts on
instruction.
any specific defendant?
I think that's really important, Judge, because obviously we're dealing with, multiple defendants, multiple counts. I think you're already going to read that instruction, are you not?
I'm gonna read 312. You may find the defendant guilty as charged of such lesser included crimes if the evidence may justify or not guilty. Guilty as charged or lesser. I'll read that entire instruction. All right. Now, we need to bring your clients in if you want to waive, you wanted them here.
Yes.
Now, regarding your client, would a cell phone video, FaceTime, be sufficient for him to hear?
Well, Judge, I obviously think it's important for him to understand what's going on in the proceedings.
Yeah.
I understand that we can't share a TV from the jury room and also in a closed circuit capacity for him in whatever holding cell he's in. So I would think the next best alternative would, in fact, be a FaceTime so that he can understand what's happening in the proceedings.
Okay. Who has a iPhone that they're willing to learn?
We can do that. I can do mine. I'd like for in here, and then if Mr. Gonzalez wants to do.
You have an iPhone, Mr. Gonzalez?
I do, Judge.
You two know each other's phone number?
We do.
Are you friends on Facebook?
I thought you were asking me if I knew my client's phone number.
I don't think Mr. Gonzalez has Facebook.
No, Judge, I have no social media.
All right, but you can video, how would he do that then?
I can FaceTime him through.
Oh, really?
Through iPhone.
Okay.
FaceTime is not
iPhone's
Facebook.
got their own thing.
I have a spare iPhone
Okay.
with no social media or.
I think those would be fun. So we're gonna need one deputy to stand there.
So Mr. Gonzalez is going to get his phone somehow to the holding cell. He's gonna remain here. Somebody's gonna take it.
The deputy will take the phone. So we're gonna bring in everybody?
Well, give it to a deputy.
Yeah.
And then I will FaceTime Mr. Gonzalez.
Will the device that goes back with the defendant with the deputy be muted on that end? Can we ensure the deputy has the device muted from
Yeah,
that
we'll just
location,
unlock
and
it.
Mr. Gonzalez can communicate with his client thereafter if
Well,
necessary?
his would the only one that need to be muted, so it'd be the only one that's in here.
Deputies can also tell me whether or not he has any reason to want to communicate.
Right, I just don't want that to be going on.
And you can stand close to the bench if you want so you can hear my instructions. And I'll speak loudly into the microphone.
Your Honor, may I confirm the standard instructions that you have indicated you will reread these? By number.
312.
Yeah, and you can be here. There you go.
It's like the first time I played Monopoly. We did.
Yeah.
And so, Danny, that one just might go like facing the jury. I think it should. What do you think? Should he be hearing what the jury, or what the judge says, or just audio and then looking at the jury, or?
That's fine.
I don't know. I'm just thinking.
I would like him to say.
So it's facing the jury, but he'll be able to hear what you're saying.
Unanimous as to the highest count for which they all.
You want a book?
Yeah. Right? Because I don't know if it's still rereading that even answers the question. See? So they agree on one.
I got a book here.
That is correct.
I got this,
They
Brian.
agree on one. Everyone says.
Even if you need something heavy, there's the evidence. Air is always good for
Is it
something.
second? Yes. are we able to give a definitive answer to that question?
Yeah.
I got it, right.
Judge, Ms. Ismer and I were kind of talking about it a little more. I know you're going to read that instruction. I don't know that the instruction really answers the question.
It answers their first question.
I'm not sure because it doesn't say, because basically the answer to the first question is, yes, it can be second, if all of you agree. If everyone agrees to first, but on one is second.
Their
then
question
the
is,
answer would-
if it's 11 to 1, does the 1 make it the crime? No, it needs to be unanimous. They need to hear that instruction.
But they need to know that the second, that it would be the lesser included offense.
No, it's 11 people are voting for first-degree murder.
Right.
And one
Correct.
person is holding out for second-degree murder.
Correct.
And they want to know if that's the case, is it second-degree murder?
And the
Right,
answer
and
is
we're not
yes.
saying yes or no, we're just rereading the same instruction they already have. Is
Yes.
it possible to turn that down until we are sending it back to the defendant?
That's why I think the answer should be yes, it would be second.
It's not second. No. It has to be unanimous. It's 11 to 1.
It has to be for the highest offense.
Prove it. So you got 11 people
But
saying 1?
but that has to be unanimous. It still can't be an 11 to 1 at any point in time for anything.
Correct.
If one guy
Which is
never
the-
comes
But
off.
if
Yes,
11
Peterson,
11 are
that's
saying
okay.
first, then they also include, that includes the lesser included offense of second. So then it would be second.
Is that the way it works?
I mean, that's a lesser.
So if 11 people vote for first-degree premeditated murder, and one person says, no, I think it's second-degree murder,
It's the highest offense for which they all agree.
they
Which
don't
would
all
then be-
agree.
They would all.
Correct,
they would all
but if they
be
have
second.
reached a yes on first-degree premeditated murder, they have reached a yes on manslaughter and second.
Do you agree with that?
Well, we have to presume that there would be a point where the 11 that are stuck on first would all say, okay, we're going to demur and we're going to agree to that it's a second degree.
Doesn't the language of their question specifically say that? Then is it second-degree murder is the end of that sentence, isn't it? The language of the question that was there?
It's not then second degree murder. It requires the 11 to then agree to a second degree murder or they're hung.
They have agreed to first.
They've agreed to
Correct.
first, and they've
The
agreed to
instruction literally.
manslaughter, they've agreed to the lesser included then. I don't see how you can't, it's a necessarily lesser included, and so it's a part assumed in the first. So if they've agreed to first, they've agreed to second as well.
Robin? I see the logic, let me just check something.
I'm just worried they're gonna be
Then the only
confused.
change would be that in front of him reading that, or on the end of him reading that would be an actual definitive answer to the question.
Yeah,
Because
I
then
guess-
legally, by law, he can give a definitive answer.
I guess if they, yeah, I guess if you have to read it, that's the way you would have to read it. Because at the end of the day, the people that are 11 are the first degree murder.
Had to surpass second to
Thank
get
you.
to first.
Right, so then, so I think if so at that point, then you would all agree on the second, because they're not on the first.
But the alternative is that they hang. The alternative is that the people that are stuck first say,
Jen, do you want to be a part of this conversation? We're just talking without, because you agree with what I'm saying.
I don't.
Wish to put your position on record. Understood.
That's a good what you're saying, clearly.
Right.
I don't have any position.
For her not to get involved.
Right.
He understands.
Look, my absence of yelling, I don't, it has to be unanimous or whatever.
that's all I'm saying.
Agreed.
But their answer to their question with the example would be, so
They-
that, so
if
at that
their
point,
question
Jerry,
did not specifically say,
so at that point, your
then
answer would
if-
be second.
but they have, they, in the
But
group,
what I'm saying to you is to answer this question by law.
It would be a definitive answer to the
It is an answer, not just reading the instruction. Ask them, we are entitled to a comment. You wanna ask for a
Can we
comment?
see the question?
yes, question.
I would like a copy as well. We need to ask for a copy. Yes. Yes. Sure, I'm just talking about their question specifically. It could be the same example.
I don't want an answer that is correct and is logical to confuse them.
Well, how do we explain that?
It could, and not how it's.
Right, so that's why I'm saying in rereading this, it's actually not helpful. Yeah. Agreed.
Okay. All right. Yeah. Let me know. Okay. Right. Well, here's the thing on this. They
Can
have
we
to
see
have-
the question?
It has to be unanimous.
Can we see the question?
I mean, that's a simple answer. It has to be unanimous. I mean, that's
I mean,
a
they can't
fact.
come back 11-1. And they would have to, they'd have to follow that instruction that says you have to agree unanimously on the highest one that you believe.
Yes, but that's not the way that the instruction actually reads, because those are two separate parts of the paragraph. So the first paragraph does
I
say
understand it
return
doesn't-
verdict for the highest.
It's
But
an
the second-
unusual question.
Yes, which is why I think it needs more guidance than just the instruction.
You might be
The
right on that.
verdict, like the standard instruction of 3.12, gives us two separate, I guess, explanations, if the court's following. So paragraph 2 does say return a verdict for the highest count. And then paragraph 3 says the verdict must be unanimous. So we're not actually resolving any confusion by not including the language. I think if the court's statement that you just made was you need to return a verdict as to the highest charge for which you are all unanimous is legally accurate and follows or tracks the same language included in the verdict form and still at least provides some guidance in answering the question.
Well,
I intend on telling them
the
that.
question is, on each count, does it have to be unanimous on a degree?
Yes, it has to be unanimous, yes.
For example, regardless, the answer to the question.
Which is why I think we need to get an answer, not just read a generic instruction.
Yes, it needs to be unanimous.
And then he can read that. But the answer to that question is yes. So the example is yes.
Okay, now question 2.
If half people are saying guilty on one count and other half are saying not guilty, does that make them mistrial without guilty?
Here's the other problem is we have 5 defendants, and we don't know whether or not they're talking about it collectively or they're talking about individually.
The answer must convert, it must be unanimous. So the answer must be, yes, for it to be a verdict, it must be unanimous. You must consider each count as it relates to each defendant individually.
That's another issue.
So that should be the answer.
Then make them now, just get them under the original map.
Is this unanimous for the entire case or specific charge?
Same answer. In that one,
It's the same thing.
It's the same question.
you must take it out.
Decide on unanimous.
It would be for the specific charge.
As it relates,
But he says regardless, the answer is yes.
And then she can read
What we would do instead is would say, I cannot give you a response to your hypothetical questions. The answer to your question is yes.
yes, it must be unanimous.
Correct, like, still read whatever we need to read, whatever, but like specify it to each defendant and specify that it is for whatever, the highest.
To each defendant as to each count.
Correct. Do you want to draft something and provide it to him instead?
If they make the copy before we're ready to
No, I
vote.
think we should.
Is there a consensus?
We're coming up with a
We're
timer
writing
on
it so we can
draft
see
something.
when we look at it. If it looks right, then we'll ask the court to consider it.
If they have an agreement, we want to just so I wouldn't read anything other than things like this.
Well, I don't know. He's gonna read it. I don't think it's outside of that. Yes, I'm gonna make sure we're on the same page.
Yeah, I'm working.
You have a sugar box right there? Yeah.
I gotta do a sentencing memorandum.
Do you enjoy the CJA?
I'm a member of it.
No, do you enjoy being on the
Sometimes.
What's the downside? Just being on call?
Yeah, fine. I mean, the pay is, I don't have any major downside. I like that. That's probably my only objection is that I wish they would call you and say,
Yes, sir.
as opposed to
need to have them review it. I think we all were in agreement. Kind of.
Am I gonna have a hard copy of it if it's agreed to?
Yeah, we'll email you a copy.
Okay, you can just email it directly to me and I'll bring it up on my
Do
screen.
you want to take a look at what she's written? Nicole, you'll be here. She's almost finishing that last one.
Yeah, well,
Just a moment. Let us
No,
finalize
like,
this.
finish it off by like the next.
Copies made after.
Nice work.
Oh, that's, as it relates. No, because that would be as a whole. Yeah, but not as it relates to one count. The question is, if they're saying on one,
don't need that yellow paper.
I don't know, it's up to you. I think we answered the questions, so we have.
I think she answered the questions, so.
I don't know what this is, you know what Asia's email is, I can use their email. We're not. We're trying to get the order of things email address.
You need my email?
Yes, Judge.
Robin.Fusine@fljud13.org.
At FL what?
FLJUD13.org.
Org?
Org.
Sorry, I had it on my
Org.
laptop, so I apologize. Thank you.
Would you send it to everybody or just?
Yes. No, I don't know, can you ask? Can you ask? I didn't know if he was gonna read through public or since you actually gave an answer. But you all tell us what your preference is on.
I don't know. Did it come to you?
Like reply all. Maybe from a jury instruction.
It's a race. Gmail should not come to me. Just this stuff. There it is. This case was
Sure.
United Destructive using CRO. So, yeah, we did it straight to, because they wanted to have more specific.
All right, I've read your questions, answers, I should say. I agree that these are fine. Does each defendant and their attorney agree to these questions?
Judge, as to Mr. Sampson, we have reviewed the answers that we intend to provide, and I have no objection.
Shetty?
I agree with Mr. Gonzalez's representation.
All right, Mr. Hernandez?
So do I, Your Honor, on behalf of Mr. Bell.
Mr. Sinoni?
No objection on behalf of Mr. Thompson.
Mr. Bradley?
I agree to those on behalf of Mr. Hammond. Are we also reading 312 and 312C, or we're just doing these answers?
I can read the 312 verdict if you want, but this basically covers that. What would be your preference? I can start out and say, I have a general jury instruction. I'll reread to you, and then I will answer each question specifically.
That can be fine. I just asked if you're going to read 312 to also read 312C.
I have that with me as well.
Okay.
All right. You may bring the jury in.
All rise for the jury.
Jury has returned. Y'all may be seated. Ladies and gentlemen, I have received your questions. It took a few minutes to round everybody up, and I discussed this at length with all the attorneys on both sides. And I'm going to answer your 3 questions. I'm going to read you 2 short jury instructions that you already have, but I want to reiterate these and then answer your questions. A separate crime is charged against each defendant in each count of the indictment. The defendants have been tried together. However, the charges against each defendant and the evidence applicable to him must be considered separately. A finding of guilty or not guilty as to one or some of the defendants must not affect your verdict as to the other defendants or the other crimes charged. You may find the defendant guilty as charged or guilty of such lesser included crimes as the evidence may justify or not guilty. If you return a verdict of guilty, it should be for the highest offense on the verdict form for each count that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. The verdict must be in writing, and for your convenience, the necessary verdict form is prepared, and you have that copy. Now, regarding your questions, the answer to your first question, I cannot provide a response to your hypothetical question directly. You must return a unanimous verdict as to the highest offense on which you all agree, if any. Question 2. You must reach a unanimous verdict as to each count as it relates to each specific defendant. If you are not able to come to a unanimous decision as to any one count, there would be a mistrial as to only that count. And if you are unable to reach a decision as to one count, there would be a mistrial as to only that specific count. It will not affect the unanimous decisions as to the other counts. You must consider all counts individually as they relate to the defendant. And I hope that gives you some clarity. And thank you.
You're on a privilege, Coach?
Yes. They didn't teach reading in law school. The answer to question 1 is yes. And just to be clear, yes. And I cannot provide a response to your hypothetical question. You must return a unanimous verdict as to the highest offense to which you all agree, if any. But that answer to 1 is yes. All right? I hope that makes things clear. And I now ask you to go back and continue your deliberations. Thank you.
All rise for the jury.
Judge, the only thing the state would request at this time is that a copy of the questions as well as a copy of your answers be sent back with them as well, so that they have them back there in case they need to refer back to what was.
Well, my answer is in the record. You want me to print that out and send it back?
I think that
Does
would be.
everyone agree to that?
I don't have any objection to that.
Anyone have an objection?
No, sir.
All right.
Now she can pay her unintelligible. She'll be able to pay rent.
She can pay the rent, you can pay the car and the insurance.
No, she should be able to pay the rent, the car, and still have a lot of money left over. She should be able to pay the light, water, insurance.
You pay more for rent.
And daycare, unintelligible.
Unintelligible.
You know what I mean? And after school, she can even drive the unintelligible.
Yeah, only I can. Unintelligible.
Unintelligible every time. I unintelligible.
Unintelligible.
Can I dump right here?
The unintelligible goes over there. Unintelligible.
Oh man, don't play with me. No, get Huh? It's going to rain, bro.
Unintelligible right there.
But I can't.
Unintelligible.
You'll see. Watch.
Unintelligible. Bro, it takes time. Unintelligible.
I'm going to do this for a couple of more years. After that, I'm getting unintelligible out. Maybe after I unintelligible the license, I'm out. Like I told you, man, I'm unintelligible. It gets boring.
Unintelligible.
Unintelligible. We're always dirty. Are you ready to do some dirt with me? You got my back?
Go.
Huh?
Park right there. Unintelligible. Right?
Huh?
Unintelligible. Unintelligible, what you say?
Do you know the good thing about me? That backlash thing I have, well, it's not registered in my name. All of these, yes. So if I don't use one of those, yeah. But no, but not the other one. Because I don't have a record. I've never had. Search for my record. You know what I'm saying? I'm looking for a spot to do it. I'll do it. 1, 2, 3, I don't care.
And are you unintelligible or what?
And put in, and it's not a man, it's a woman.
The one that works there?
Yes.
Unintelligible.
Unintelligible.
Unintelligible man.
I told you who it was a while ago.
Okay. Now, could we go ahead and maintain that same procedure on audio session 3 of 39?
That girl is talking. Yeah.
Also, this date.
Oh, yeah, we were right. Some damaging stuff on this tape, allegedly coming out of the defendant's mouth, saying, I'm looking for a spot to do it. He's saying the good thing about me, and then he references something not registered to him. One could make an inference, perhaps a firearm he's referencing. Also says, are you ready to do some dirt with me? Not a good look for this defendant if these things were said by him on that tape we're listening to. What we're going to hear after the break, apparently, he makes a comment about looking for a spot to dump her. The inference being dumping Tanya Wise's body. That's the inference. We're about to hear it together live. Don't go anywhere. We'll share it after the break. Welcome back to Court TV Live. Oh, it is getting good in the pregnant mistress murder trial because there was an intimate conversation between the defendant and his nephew that there is a recording of. This seems allegedly like a murder plan being discussed. We're about to hear the defendant say, "I'm going to blow her brains out." Let's go back in.
Is talking shit.
Which one?
The one that you unintelligible and her little man unintelligible.
Do you want me to tell you what is going on, or do you prefer not to know?
Unintelligible.
No? What?
You're the only one that unintelligible and you don't lie. They should know who unintelligible, bro. Unintelligible.
And I'm not the only one. Can't take chances. I lose everything. No, I am telling you the truth. If something happens to me, you already know. I'm going to blow her brains out so she doesn't talk. I have to do it, Eric. I have no other choice. I'm going to lose everything. What I need is someone to drive me. That's it. Unintelligible. But nobody knows. Everyone is talking. That's the point. She was nagging that she was pregnant by him. She says it's not his. If my wife found something out like that, oh my God, bro. I lose everything, bro. Unintelligible. Brief pause. I have his spot. I already have her. I'm telling you the truth. I've already prepared her well. I told her that there are some people that want to pay her because she unintelligible. And she asked me, will you go with me because I don't know them? I told her, yeah, I'll go. Throw me a couple bucks my way. You know what I'm saying? I have to find a spot and dump her there. You know what I'm saying? How did you do it? At night?
Yes.
That's the first thing. And find a spot where there is not
Unintelligible, and that was it.
She has threatened another guy. The guy is giving her money. That bitch is nasty. She plays like a man.
What's up with that boy? Unintelligible.
The what?
Unintelligible. That damn bitch, unintelligible.
Look, leave here in something like that. In something like that. Leave her. No one will find her. Like what they who was in there. If I do it quietly, nobody is going to unintelligible.
Unintelligible.
I'll do it quietly. No one knows anything. That's why I was telling you unintelligible. Because of things I am going to be wearing, nobody here knows you or me. Nobody has to go to my house. If they go to my house, unintelligible, I'm just saying, little by little, I'll throw away all the clothes, or I burn them or wash them with Clorox. Because I was thinking of you, unintelligible is faster. Because no one is going to see you, unintelligible. But that's it. Done with it, right? I'm looking for a spot.
Where does she live?
Huh?
Where does she live?
Behind Wendy's.
Wendy's, but where?
Why? What are you thinking? Give me an idea.
We can go to where she lives, unintelligible.
If this would be happening back home, it would already be done. It would have been done. It would already be done. And the good thing is that I don't go anywhere. Who is going to accuse me of anything? If I'm not with you, I'm with my wife. No one knows, unintelligible. I can't tell anyone anything, nothing. I think we want unintelligible a lot of these things, unintelligible all. And I, unintelligible, look like this. Look.
Unintelligible.
No. If I use my truck, I'll cover the plates.
Unintelligible, nobody, unintelligible.
No. Call her outside, unintelligible, by telephone and blow her brains out there. You know what I mean? And take the phone. And all that. I need you to help me do that. I'll leave you.
I'll take it to Miami, unintelligible.
I checked the trash and...
Unintelligible,
What?
unintelligible,
What about it?
unintelligible,
I can't hear what you're saying.
unintelligible,
That I put... I, unintelligible.
bro, unintelligible. He did it, bro.
Because he was...
Yo, when I was unintelligible.
She was camming, dancing in front of the camera. That's what she does.
And she, unintelligible.
In the end, she can't. No one can do anything. You already know. You know what I'm saying? Unintelligible. The mafia, unintelligible. That is a good part. That's the only good thing I have.
Unintelligible.
Huh?
That's what you don't know.
Because I'm supposed to pick her up one of these days. That is why I'm telling you. If you drive, I blow her head off there in a drive-by. It's good back there.
Remember that they're unintelligible.
Ah, but unintelligible. You put the barrel in her mouth and unintelligible. That's it, bro. She won't get up ever again. Dead people don't talk. And if there's no evidence, what are they going to do? No one is going to find out it was us.
Unintelligible.
I have it already. Gloves, everything.
Unintelligible.
All we got is this.
Uh-huh.
I'll pull over and wash my hands and take a little break. Eat something real quick. See the children, and then we'll... Unintelligible, you know.
Unintelligible.
Yeah, we're not unintelligible.
Unintelligible.
I'm tired, brother. I'm trying to think how to make that problem go away. But I have to do that because then I won't do it later. And that's the easiest thing. Take her somewhere, and that's it. You are the only one knows about this, and I know you won't, unintelligible, me out.
I know that, unintelligible.
Oh, yes. Relax, dude.
Okay. And Ms. Campos, can we go ahead and start?
Ooh, stick a fork in him. He may be done after the jury heard this. Let's bring in criminal defense attorney Nicole DeBoard. Nicole, we thought this was going to be good. Was it even better than you may have imagined?
I think it was even better, and Wu is right. This was sort of the put a fork in it evidence that you predicted it might be. This is why the defense was doing everything they could to dot all their I's and cross all their T's as it relates to trying to make sure that any potentially inadmissible evidence did not come in. You could see the defendant's face as all of this was coming into evidence. Even he knows this is disastrous. So I think that this is going to be tough for the jury to overcome.
Yes, and I'm so glad you mentioned his reaction, Nicole. Thank you for that, because some of the folks in our newsroom were noticing how it almost looks like he's smirking at points, like we caught a couple glimpses of him. This is some tape we rolled back while he's taking it in. Here he's pretty straight-faced, but there are a couple points where he looks like he's expressing some disagreement. There you see it there, almost a little bit of a smirky type smile. Nicole, do you think the jury was fixated on him as they were listening to this?
I think they absolutely watch the defendant. When some evidence is coming in, they want to see, like this. They want to see, how is the defendant processing this information? And I don't know how they're reading it. You know, none of us know what's in their minds, but I'm certainly watching this and the smirking and almost the laughing and thinking, you know, this is a they got me face. We don't know what the jurors are thinking, but this was really rough evidence.
Yeah, really, Nicole. This is bad stuff. You know, and then it kind of, it sort of, how do I want to say, discredits maybe is the right word. You know, the defense theory is that some other person did this, and they have really set up this theory for the jury to think that it could have been any one of these violent partners that Tanya Wise was sadly with, or some of the people that haven't been shown to be violent, but just that their DNA happened to be on her body at the scene. And so they cast a lot of doubt as to the idea that this defendant could do this and tried to make him seem so removed. But then we know they would have that discovery. They know he said this. So I'm wondering, Nicole, do you think that it was a mistake to kind of go for that theory?
You know, it's hard to, I really don't ever want to second guess the defense. I mean, certainly there are a lot of other potential alternative suspects. There are lots of issues concerning circumstantial evidence. And I think that they have to do what they think is right in terms of pointing out those defects. It is always an issue when you have conflicting theories or evidence that's going to be really destructive to consider. Does this impact the credibility of the defense? If you bring a theory that is debunked by some, in this case, really violent language about what this person is going to do to the person who now is deceased. So certainly it can backfire, but I hate to second guess a defense team when they're trying to put together the best they can with really tough evidence.
Sure, sure. Nicole, excellent insight. Thank you. We'll hit pause on this testimony. There's more. Conversation's not done yet. Share with us on social media your thoughts about it and how it's going to impact the case. Thank you for being with us on this Wednesday morning.
My two best friends were just murdered.
Join me for a Court TV true crime series where we take you from the crime scene to the courtroom.
Donna Adelson hates every piece of grass that Dan Marcel ever walked on.
It's something that'll haunt all of us forever.
It always seemed like he was covering or deceiving.
This was a whole different level.
Victim to Verdict with Ted Rowlands, a Court TV original series. Season premieres September 27th.
Only on Court TV.
Back to court we go. We're hearing that very damaging conversation that was recorded between the defendant and his nephew. At one point he said, in reference to Tanya Wise, presumably, "I'm going to blow her brains out." Let's go back in.
Session 4 of 39?
Yes,
Okay. And on what date does that fall?
that is the same date of August 21st, 2018.
Okay. And can we follow that same procedure?
Yes.
You know, I got a nice way of unintelligible.
You got it planned out?
You got it planned out? I'll go pick her up. I'll pick you up first and I'll drop you off at the corner somewhere. You get in the back of the truck and you'll say, drive, like if you're robbing me first. And I'll tell you where, unintelligible. I'll call you Nico, like I think I know, unintelligible, Nico.
Unintelligible.
Unintelligible, like, nah, my name ain't Nico, this is unintelligible. Know what I'm saying? That way, I need to do what I got to do. Then she won't try unintelligible. It tells me 95 and unintelligible.
Unintelligible.
There is a field nearby in St. Unintelligible. There's a field there. We don't have to go too far to unintelligible. Oh, that'd be unintelligible tonight, unintelligible. You know what I'm saying? Unintelligible, and there are no cameras around my house. If she invites me somewhere, unintelligible.
Unintelligible.
Oh, I won't even get to that because nobody will know anything. You can't prove anything if no one saw anything. Unintelligible. I was thinking of taking her to some field nearby the route. Do you know where I go? Unintelligible. Unintelligible. When she go in there, she disappear for a couple of days. Unintelligible. She does that. She disappears for 2 or 3 days like that. She always does that. Unintelligible. Some guys that this and that her phone, 3 days. And I'll take her phone, unintelligible, and I'll throw it away. I'll throw it away or I'll burn it. They can't do anything there, unintelligible. I have everything planned out. I'm going to let her drive because I have unintelligible. She doesn't drive and use a phone for texting or nothing. I'll play dumb. You know what I'm saying? I'll sit in the back like we're going to do something. You know what I'm saying? What do you think is easier to? Unintelligible. Inside the bushes or outside and then dump her?
Inaudible.
Unintelligible. First, right? Then hit her and then dump her, right?
Unintelligible.
Huh?
Unintelligible. Is she saying that?
About what?
That it's yours.
No one. She hasn't told anything to anyone. She only told me. I am the only one who knows. It's been going on for a minute.
Unintelligible.
Several times she has already, but I already know.
Inaudible.
The thing is that I'm trying to catch her alone. She hasn't told anyone. Saying she hasn't dared to tell Debbie anything because she doesn't want to do that. You get what I'm saying? She's trying to help me. She doesn't want to protect me like that, but unintelligible. If that child is not his, unintelligible. That's what she's going to do. She's unintelligible. What you have to tell her is that you're going to the party too. Unintelligible. She doesn't have to. Unintelligible.
Unintelligible.
The less she knows, the better. No one should know this. No one. Why do you think I didn't want to go to church?
Damn.
Chuckles. Unintelligible. When we get to the yard, unintelligible, pull up my truck over there. We'll get our stuff.
All right, man.
Park it. get in the truck or unintelligible. That way I can... As you can see, there aren't any lights here. Do you notice you can't see anything here? Simply a street like that one. That's closed off, unintelligible. When she ends up like that after a couple of days, and one is already calm.
Oh my, this is a bad morning for this defendant, that is for sure. You got to wonder what the jury's thinking after hearing this, and it goes against the defense theory of the case that someone else had reason to harm her, someone else was the person. We'll be right back.
This is Court TV Live. I'm Kelly Craft, in today for Ted Rollins. Thank you so much for being with us. We are in Florida this morning for the pregnant mistress murder trial. Married father of 4, Jose Soto Escalara, is accused of killing his pregnant mistress. This was back in 2018. 23-year-old Tanya Wise, you can see her there. She was found in a ditch by the side of the road. She had been 8.5 months pregnant with Jose's child. Let's get you back into court now. We are listening to a conversation, and it's an interesting one to say the least. This is between the defendant and his nephew with the help of an interpreter.
Like that after a couple of days, and one is already calm. The good thing about that one doesn't. The one doesn't leave a trace. So it can be anyone. In that way, unintelligible, the barrel there, but if you don't leave it there, there's no evidence. That's like the automatic that I have. Because the bullets leave the mark, unintelligible, that doesn't leave trace. That doesn't leave a trace. The cartridge, you clean it really well. No, and she talks as if she loves him. She knows the...
So she knows?
Huh?
She knows?
She knows a few of them.
Unintelligible.
That's why I want to buy a gun and leave it at your house. As long as it pops off, unintelligible. How unintelligible going to do that? They don't think unintelligible. We put the unintelligible in the there, through there. Unintelligible, my house.
Unintelligible. You know what I mean? I don't want unintelligible.
Unintelligible, because if I do something and take her out, and if someone comes that could, no, I'm screwed, and you leave. You get what I'm saying?
Yeah.
And I'll stay there with you until she leaves. Something like that. Look, really deep in there.
No.
Relax. No, I want you to see further ahead. I'm going to show you something. When I leave here, I'm going to go in there, ahead. No, I can't, unintelligible, that she opens her mouth. And I know she, unintelligible. I don't need that. I can't afford unintelligible. I'll lose it all. Everything.
Unintelligible. She would believe you.
Huh?
Unintelligible. She would believe you.
Who? Debbie?
Okay, Ms. Campos, do you see session 5 of 39?
Yes.
And on what date does that fall?
That is October 23rd, 2018.
Do you mean August 23rd?
I'm sorry, August 23rd, 2018. Yes.
Thank you. Can you go ahead and continue?
Yes.
Bro, my thing is, was just, it's like what you said. It's not like, nah, I quit, unintelligible. All that noise. I got everything planned. Go home, get some tools, tell my wife I got to go to work on a bike, real quick. See what's wrong with it. Why I won't start. Pick it up. Bring Eric with me. Take it home and pick it up. But unintelligible. And what you're going to do is drive. That's it.
And Ms. Campos, do you see session 6 of 39?
Yes.
And on what date does that fall?
August 23rd, 2018.
Okay. If you can go ahead and proceed, continue the same procedure.
Right there, they look down, unintelligible.
Yeah.
And there are cameras right there.
Unintelligible. The floor.
Unintelligible.
Huh?
Unintelligible.
Nah, unintelligible. Oh, and I didn't either. Look.
Unintelligible. Stop, drop, and roll. Unintelligible.
Huh?
Unintelligible.
Ms. Campos, turning your attention to audio session 7 of 39. Do you see that?
Yes.
And on what date does that fall?
August 23rd, 2018.
Go ahead.
So that's the spot that looks better so far, right?
Yeah, make sure unintelligible.
What do you think about choking her, unintelligible?
Huh?
Is it better than a blow and just get it over with, right?
Unintelligible. It would be better.
Unintelligible.
Unintelligible. Is that it?
Yep.
Unintelligible. There.
So, up here, and I, unintelligible.
Unintelligible, huh?
And do you see session 8 of 39?
Yes.
Same question. On what date does that fall?
August 23rd, 2018. We need something like that. A barrel.
And you see session 9 of 39?
Yes.
On what date does that fall?
Also August 23rd, 2018. Right in here, too, unintelligible.
There are no lights here. There's nothing. Look, nothing. Not this one, not this one. This one, unintelligible. Unintelligible. If we come this way, pull over. Yeah, over here somewhere. So if we come this way, pull over.
Yeah.
Plus, I'm getting rid of my truck, unintelligible, about the tire pressure or none of that.
Unintelligible.
I just can't do it unintelligible inside my truck. It won't hurt me if it's not my truck. I got to strangle that bitch. You can't leave no blood or nothing in the truck. I don't want nothing, nothing, unintelligible, nothing. If they ever come asking anything, there's nothing. It's like you said it. There's no other way around it. It's like you said. You got to unintelligible. Blame her boyfriend because they're always fighting. You know what I'm saying? She now has a record in which something did something to her. Someone did something to her. You know.
Post, do you see session 10 of 39?
Yes.
And on what date does that fall?
August 23rd, 2018.
Okay.
You're going to take me unintelligible from here, unintelligible.
Who?
Magali.
Why?
What happened?
Huh?
If they ask.
That I know of lately, no. Sometimes, yes. She was telling me, listen, you got them on this side right now, the leverage.
Unintelligible.
Because unintelligible. Because I need it like that. I have all the cartridges, all of them ready. Whenever you're taking the book bag, I'll drop it off at your house. My shotgun shells are accounted for my new shotgun. I haven't even fired it. So get it. I need someone to drive so I can unintelligible. Yo, look up that thing.
That's what I'm going to do.
About those unintelligible they found at the Dunkin' Donuts. Look it up on my phone and save it.
I'm going to read it.
I want to see if I save some money so we can into business. I already talked to unintelligible for the business. Unintelligible.
Unintelligible birthday.
Unintelligible. Are you sure? Do you swear on your daughter that you saw them together yesterday?
Yeah, on my birthday.
That's perfect. That's perfect.
Unintelligible inside the car.
You know what would make it easier? That she'd come to pick me up in his car.
Unintelligible.
Bye. And I'll take off in the car to unintelligible. Like in unintelligible. Water somewhere. Somewhere. A house where there's no camera. I don't know nothing. You know what I'm saying? And at unintelligible, and it's not on my street, it's too dark, and it's hard to get out.
Okay, Ms. Campos, do you see session 11 of 39?
Yes.
And on what date does that fall?
August 23rd, 2018.
Thank you.
Hey, up here also, unintelligible, where unintelligible.
His car, unintelligible. Leave it abandoned over there.
Unintelligible.
Unintelligible.
Unintelligible. His car and unintelligible. And it wasn't my car. Unintelligible car.
Unintelligible.
Okay, Ms. Campos, do you see session 1239?
Yes,
And on what date does that fall?
August 23rd, 2018.
Do you know what I want to do? To give you the package with all those little shovels. Since you're going to Miami on Saturday, throw the package unintelligible in the trash. Make sure that no one sees you. Like, I'm good though. I'm good, unintelligible. Like what you said makes sense. The blow, that's it. Everything ends. Like that, you don't have to worry about anything. You don't got to worry about nothing. The blow.
I would have did it by myself if I didn't have a daughter, you know. That's the unintelligible. That's the thing. I don't want my unintelligible broad daylight. I'll probably go to jail, unintelligible. I'm like, yo, I ain't going to jail.
Or to take her to unintelligible.
Yep.
Oh well, she has to go because she
A lot. She's got Manny scared.
Yeah, she does.
Not me. If she'd do that to me, she would have been gone, unintelligible.
The thing is that I haven't had time because Debbie always has a pissed off face, you know? Where are you going? Why do you have a day off? You know what I'm saying? So listen, I'm going to fix a bike and I'll be back.
Yeah, without Leroy coming to get unintelligible.
Huh?
That's the only way, you know what I'm saying? The back way too, but with his car too.
I know, but if there are no cars, unintelligible, it's like I told you. I have to do it because she trusts me. She thinks she's going to make money. I'm going to have the money so she can see it and not think anything of it. I'll leave the money here inside so no one takes it. You know what I'm saying? Really easy. Like that, like that. Walk with me over there. I can do it alone. I don't care, but two set of eyes are better. If you keep eyes on things for me, I go in calmly. I take my time like nothing, like nothing. I remove the ass from the trunk. I remove the unintelligible from the front and unintelligible in case they see me. You never know, unintelligible.
Unintelligible.
Get the keys. No one will see anything. No one will see anything there.
Yeah.
Right there, right there. It's far over here. It's better because over there, you got to, I already have. I'm making it look like she unintelligible with someone somewhere else. I'm not stupid.
All right, as they are presenting this evidence, we're going to squeeze in a quick break, but don't go anywhere. We're going to come right back, and we're going to hear more of these conversations. Stay with us. You're watching Court TV Live, your front row seat to justice.
Young mother found brutally murdered.
Now the victim's boyfriend, a married father of four,
is charged for the murder of his alleged mistress and her unborn child.
The pregnant mistress murder trial. Live coverage today, only on Court TV.
Saturday nights on ION
Is our night.
Let's go! Double headers every Saturday at 7 and 10 p.m. Eastern. The new Saturday Night Out is on ION all season long.
to court in just a moment, but first, here's a quick look at some of the other cases that we are tracking here at Court TV. In Florida, the jury in the murder of Suni Bell, they have apparently reached an impasse, asking the judge earlier this morning for direction. If not all of them can agree on certain charges. They are back now deliberating the fate of 5 men accused of killing a 4-year-old girl during a drive-by shooting. We will take you there live as soon as we have a verdict in this case. They have been deliberating for more than 10 hours. Also in Florida, we are expecting to hear from defendant Herbert Swilley's daughter today. This is in the dosed and choked murder trial. He's accused of drugging and strangling his husband and then staging a fake crime scene. We will keep you updated on all of these trials throughout the day. But for now, let's head back to Florida for the pregnant mistress murder trial. Right now, we are listening to some conversations the defendant had with his nephew with the help of a translator. Let's go back in.
I'm not stupid. I know what I'm doing. So what I need is for someone to drive me so I won't feel panic. Unintelligible. Hurry up. Get back. Unintelligible.
Ms. Campos, do you see session number 13 of 39?
Yes.
And on what date does that fall?
August 23rd, 2018.
Do you see this new street? There's nothing here. There are no cameras. You see? Look, there's nothing here. Here, there's nothing here. Look at this. All this over here is all clean. There are no cameras here anywhere, okay? Nowhere. Look, nowhere. Right here. Unintelligible, and it gets done quickly. I think unintelligible.
Ms. Campos, do you see session 14 of 39?
Yes.
And on what date does that fall?
August 23rd, 2018. Unintelligible.
Nah, I already found a spot.
Where?
I'll tell you right now, unintelligible. Here, and how we dump the trash, unintelligible. There's not going to be anything here. To put her...
Intelligible.
That's it. I'm done. Right?
You have to unintelligible with unintelligible.
If I don't see her unintelligible down here, unintelligible around there, but you need to know.
That's far.
Huh?
Unintelligible.
That what?
Only cows live in there.
Good. Right? That's it. It's over. But there's a lot of tires here. Look, a lot of tires.
Unintelligible. There's nothing unintelligible.
Do you think it can be done easily with 2 people?
Unintelligible.
And Ms. Campos, do you see session 15 of 39?
Yes.
And on what date does that fall?
August 23rd, 2018.
And do you see session 16 of 39?
Yes.
And on what date does that fall?
August 23rd, 2018.
Okay.
That's it? Unintelligible. Go in there.
Huh?
The unintelligible go in there.
They go in there?
Unintelligible. The trash. Unintelligible.
There, where you were standing?
Unintelligible.
I saw that entrance. I'm not going to go through there anymore. You don't want anyone to find her. Unintelligible. But that's a good spot, right? So, what I'll do, I'll turn this way.
Unintelligible left.
I don't know what's down there. There, it will look like someone did it. Left it there and took off. Unintelligible or got lost.
Unintelligible.
Fuck. In there. No, but where you went because you can walk.
Oh, yeah.
It's easy. You don't have to work too hard. I'll bring her. I already have it planned. When unintelligible her, you come with me, and I'll make her drive. Unintelligible. I'll drop you off right here so she won't have time to use the telephone.
That's unintelligible.
I'm going to bring the tools like I'm going to fix something. Unintelligible. Here. You see what I'm saying? I got, then, unintelligible to talk to her, to unintelligible the story.
That's it. That's it. Unintelligible.
There. No one will hear her if she screams. Nothing. No one will hear her. The thing is, she is not going to scream. What do you think? Is it better to go in through one side and leave through there, or not to in there first? Right? Leave through there.
You can walk with her.
Okay, Ms. Campos, do you see session 17 of 39?
Yes.
And on what date does that fall?
August 23rd, 2018.
No. Stressing, unintelligible. We put her in there and that's it. Or we hit her and drag her, unintelligible, and she won't be able to move.
We'll go in there.
Huh?
Be like, yo, we're going to unintelligible.
No, the money. Unintelligible, the money.
Okay, and do you see session 18 of 39?
Yes.
What date does that fall?
August 23rd, 2018. There might be a unintelligible.
Huh?
Unintelligible.
Unintelligible. Or the other one?
Unintelligible in there.
Unintelligible.
Yep.
It's far from the house. You know what I'm saying?
I don't know why she doesn't tell her mom it's Brad's.
No, she already told her mom that it's Brad's. That's why she doesn't get anyone in trouble.
Why does she keep nagging then?
It's not that. He is not pestering me, because sooner or later, I don't want any problems.
Oh.
She is not threatening me, but she has a lot of issues with everyone, and I'm one of them. I don't need that.
Ms. Campos, do you see session 19 of 39?
Yes.
And on what date does that fall?
August 23rd, 2018.
The only one who can talk is her, and if she isn't alive, she won't say anything. I was killing myself, looking and looking for unintelligible, and I forgot that mine is not registered. I bought it unintelligible like that. That's what you need to find. The first chance you get to see someone selling something, let me know. We need that.
And do you see session 20 of 39?
Yes.
And on what date does that fall?
August 23rd, 2018.
Yes, because what I'm going to do is leave the house in flip-flops, unintelligible, and shorts. I already have everything stored away. I did it this morning. Did you think I was unintelligible?
I know.
What I have at home is the shotgun, which I had to take out from under the bed. My wife doesn't even notice that. She doesn't pay attention to that, unintelligible, and she doesn't even notice. And what's good about here is that we can always see. You know what I'm saying? Pretend to find out, you know, so we're good.
The one I'm going to feel sorry for is her son.
Her mother takes care of him. That child is never with her. I don't know who the dad is. She's unintelligible. You don't listen to me when I talk to you about her. What you don't know is that she disappears for 1, 2, and even 3 days. She just takes off recklessly to do her own thing. Is that good? She's gotten in trouble with me, with the police. She has a record. She's not the kind of person they'll be searching for like that. Nah, it could be after a week or two, or maybe even a month. But if they don't find anything within...
All right, they are taking a little break there in court. There's a sidebar. So why don't we bring in our guest this hour to discuss. Joining us now from Los Angeles, California, trial attorney Krista Rainey. Krista, thanks so much for being with us today as we listen to the state present evidence that does not look very good for the defendant in this case. And just how crazy is this? So he's a garbage truck driver. These are recordings from when he was driving the garbage truck. And defense counsel didn't want this kind of conversation admitted because it looks like a confession. And they argued that these transcripts, that these audio recordings could not be properly authenticated. The judge is allowing them to be read in court. and he did put some restrictions on him, but not that many. But this is pretty much indicating that he did it.
Well, yeah, that he planned it with his nephew, apparently. And what really got me in the conversations was he just said, it's not like she's threatening me or anything. But he still, like, had to have her killed. It was just, I mean, it's an extraordinary confession, really, to listen to this play out. And I think that the judge is right. I was thinking about this morning when I was listening to the oral argument on it. And I think a judge probably should have the more, I think, sound way to do it is have a certified court interpreter translate the recording and then have it read. This was done by an FBI interpreter, so I think that that's a little questionable, and I understand why the defense attorney objected to it, because that is not, someone who is certified by the court to interpret foreign languages. So I think that that's probably one of the bases for it, or at least that would have been mine. But it's in, and it's pretty bad.
Yeah, it's really bad. And we're hearing a lot of unintelligible. And, when a judge takes a look at something like that as to evidence that might be coming into play, and if large portions are unintelligible, that could be looked at as unreliable, untrustworthy for the jurors. But here, even though we're hearing a lot of unintelligible, the comments, the conversation is pretty clear what was going on.
I think that the blanks could be filled in pretty easily. At one point I heard unintelligible me out. Well, that was rat me out.
Yeah.
I think a lot of the blanks could be filled in here. And I trying to imagine it if I was actually listening to the tape. If the tape was in English and being played in court, you would also hear a lot of that, garbled conversation that is unintelligible, but yet you would still be able to put together the whole conversation. The only reason why they're playing it, here, or not playing it here in court, is because of the Spanish language, and not having jurors that are necessarily fluent in Spanish. I mean, it's not the language spoken in our courtroom. So I think that that's, what I'm trying to imagine. If I was listening to it, you'd hear the garbled, where they're saying unintelligible, but you would still be able to put the whole thing together. I think it's reliable information.
Yeah, absolutely reliable. Krista, thanks so much. We're going to squeeze in a quick break. Don't go anywhere. We're coming right back with more of this case in Florida. You're watching Court TV. I'm Kelly Craft in today for Ted Rollins. Back now to Florida, where we have been following day 3 of the pregnant mistress murder trial. Defendant Jose Soto Escalara is facing the death penalty if he is convicted of murdering his pregnant mistress, Tanya Wise. According to court documents, the body of 23-year-old Wise was found face down in a roadside drainage ditch. This was back in August of 2018, and she was 8.5 months pregnant with his child. Let's go back into the courtroom now. That sidebar is over. We're still listening to some conversations that the defendant had with his nephew. This is with the help of a translator. Let's go back in.
Mother takes care of him. That child is never with her. I don't know who the dad is. She's unintelligible. You aren't. You don't listen to me when I talk to you about her. What you don't know is that she disappears for 1, 2, and even 3 days. She just takes off recklessly to do her own thing. Is that good? She's gotten in trouble with the police. She has a record. She's not the kind of person they'll be searching for like that. Nat, it could be after a week or 2, or maybe even a month. But if they don't find anything within the first 48 hours, they can't do anything. She's MIA right now.
Yeah.
You see, not here either, because all of this is new. They're installing everything.
Yeah, I see them over there.
Yeah, so that's nothing. That's for the traffic. No one is going to see anything here.
Yeah.
Do you know what's good? What did you throw away in the trash can? Unintelligible. So if someone looks there, someone did that to her somewhere. Did you see it? Without us knowing anything? I really want to leave 2 or 3 of those cartridges laying around there. But no, unintelligible. You know what I'm saying?
Ms. Campos, do you see session 21 of 39?
Yes.
And on what date does that fall?
August 23rd, 2018.
Unintelligible. It can be done here too.
Unintelligible.
There are no houses there.
Unintelligible.
Nah, it's better over there where you said. You walk in there, leave here, and leave.
And do you see session 22 of 39?
Yes.
On what date does that fall?
August 23rd, 2018.
What do you think? Is it better to enter from this side?
Nah, unintelligible.
No, I can't do it, unintelligible. It's that way, right? Over there, unintelligible. No one is going to look for her back there. You know what I'm saying?
Sure, unintelligible.
Depending, unintelligible.
Unintelligible through there. Unintelligible through there.
Unintelligible. Do you know why it can't be done there? That's a track for the band. Yes, right?
Yeah.
Unintelligible. There? Unintelligible. Don't you see it?
I'm just saying unintelligible.
Unintelligible. Through there. More that way. Over there toward unintelligible. I can do it on next street. I can go in. You know what I'm saying? The one in the middle, unintelligible, dude. This is the street. I take it right here and knock down the street, right? No one will look there. The best thing would be for me to go in there, in through there, and from there. I go in here, through here, because I know the route. Do you know what I mean? That's what unintelligible, because that's what unintelligible, the ground. Look, unintelligible.
Are you going through there after all?
Nah. When I call, I'll remove everything. I'll take out the unintelligible from the front. Unintelligible because otherwise a license plate, unintelligible. So I'll get there and park. Make sure there's no one around. Unintelligible.
Unintelligible.
Unintelligible here. Unintelligible. So, unintelligible.
Unintelligible.
Well, yes, unintelligible.
Unintelligible.
The good thing is about that shotgun, or whatever shotgun, it's untraceable. You know, unintelligible is untraceable too.
Nah.
No, that it's necessary to have someone drive. So when I'm walking with her over in there, unintelligible, inside, unintelligible, and I'll dump her there, leave the bitch right there, I was reading the story of that. They've been dead there for about 2 or 3 years, and when they did that, they did it. Unintelligible. There's no proof of anything. They can't even get fingerprints or anything. Nothing.
How unintelligible did it is smart.
Same word for unintelligible.
And do you see session 23 of 39?
Yes.
On what date does that fall?
August 23rd, 2018.
Do you have somewhere to hide that?
What?
That gun. If I give it to you, do you know where to hide it?
I can't hide it at my house.
No?
You can bury it.
It's just that that won't a trace anywhere.
Unintelligible. You can bury it.
I will.
You got to bury unintelligible.
I'll have someone else store it.
Unintelligible.
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 Like, clean it real good to take off all the fingerprints. All of them. Unintelligible. This bitch, unintelligible. If you got to use it, then you use it.
I don't know what you're talking about.
Exactly. Unintelligible. No, that's the best place. No need to look any other one. Right there, right there, right there is where unintelligible is. No one is doing anything there. No one unintelligible here.
And do you see session 24 of 39?
Yes.
Okay, on what date does that fall?
August 25th, 2018.
Unintelligible that. They checked the baby.
You think so?
Unintelligible. But that has nothing to do with that.
Time for a break. We will be right back. That verdict clock is still up in the case we're watching, the other one in Florida, nearing 11 hours of deliberations. We'll be right back.
My two best friends were just murdered.
Join me for a Court TV true crime series where we take you from the crime scene to the courtroom.
Donna Adelson hates every piece of grass that Dan Marcel ever walked on.
It's something that'll haunt all of us forever.
It always seemed like he was covering or deceiving.
This was a whole different level.
Victim to Verdict with Ted Rowlands, a Court TV original series. Season premieres September 27th.
Only on Court TV.
Back now to Florida for day 3 of the pregnant mistress murder trial. It has been 7 years since the body of 23-year-old Tanya Wise was found in a ditch off of a rural road. Now the father of her unborn child, Jose Soto Escalara, is facing first-degree murder charges in connection with her death. Let's go back into the courtroom now and listen to more of these conversations between the defendant and his nephew.
But that has nothing to do with that.
Unintelligible.
Huh?
They're going to have questions.
That's all right. Unintelligible. Unintelligible. You going to take my truck to the house.
Unintelligible work. Unintelligible.
I don't have anything. Unintelligible. Unintelligible. But I don't know her.
I'm telling you, bro.
That talked.
Who?
I should call unintelligible, right?
Unintelligible.
Yeah, I know. Panic. Just stay calm so we don't have problems. Unintelligible.
Okay.
Damn.
And you see session 25 of 39?
Yes.
And on what date does that fall?
August 25th, 2018. What did they tell them? Females.
They questioned them. They asked if unintelligible.
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 And you see session 26 of 39?
Yes.
And what date does that fall?
August 25th, 2018. Unintelligible.
Huh?
They questioned everybody that day. An Uber, unintelligible, and showed a picture of her, unintelligible.
Unintelligible.
You see session 27 of 39?
Yes.
On what date does that fall?
August 25th, 2018.
Hello? Hello? Hey, Mom. I got to go to the police station because the detective, I guess they want to talk to me about Brandy. Don't, unintelligible, your house. Yeah, all I'm saying is that if they asked you if I was there leaving the laundry, unintelligible, laundry, that I was there washing clothes. Because when I left, I told my wife that I was going, unintelligible, to wash, unintelligible. 8 at 8. Yes, yeah, 8 p.m. Yep, that's it. And they might question unintelligible. I don't know. You don't know. But take out unintelligible. Uh-huh, yeah, that's it. All right, unintelligible. Oh, yes, I have unintelligible. I have unintelligible.
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 All right.
Do you have the call I made to you at 8 o'clock? I called you, right? Do you have it on the phone?
And do you see session 28 of 39?
Yes.
On what date does that fall?
August 25th, 2018.
Like 15 came to the house already.
That's crazy. Unintelligible.
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 Unintelligible. Stay calm. Unintelligible. Unintelligible. I plan to do that because unintelligible.
And do you see session 29 of 39?
Yes.
On what date does that fall?
August 25th, 2018.
Unintelligible. Bunch of cars. Unintelligible.
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 I know, but unintelligible. Go there and be like, what's going on? Unintelligible.
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 Nah. Unintelligible.
What does it have to do with that? Unintelligible.
Just because I leave my house at night doesn't mean that I go unintelligible. I fix motorcycles. Unintelligible.
Unintelligible.
And do you see session 30 of 39?
Yes.
On what date does that fall?
August 27, 2018.
I wanted to leave this unintelligible.
Unintelligible.
Huh?
No, you have to put it away. Unintelligible. Have to go.
Because they already did what they had to do. Do you know who they arrested from here today?
Who?
Hold on a minute.
And you see session 31 of 39?
Yes.
On what date does that fall?
August 27, 2018.
I'm not going down that street today. I'm going to take a right.
Unintelligible. We didn't do nothing. You didn't do nothing, so it don't matter.
I got to be worried about unintelligible truck. Unintelligible.
Huh?
I got to worry about unintelligible. She knows so many things, bro.
Unintelligible.
First one,
Unintelligible.
I'm going to work normally, like unintelligible. What I give you, you know already. You're smart.
Unintelligible.
Unintelligible.
Still with us, trial attorney Krista Ramey. All right, so Krista, there are times in these conversations where you do hear him saying things like, I didn't do anything. So, you know, he has that. Eventually, he's going to be saying something along the lines of maybe he was set up. Helpful to the defense?
I mean, I think at that point, maybe you can argue that he's already a suspect at this point. The police are calling him in. I kind of thought about that too. And I think that how I would interpret that as a prosecutor and argue that is that here you're having to go, it wasn't me. I didn't have anything to do with it, kind of as understanding that that people may be listening to him in his conversations at this point. And so I think that is kind of the more likely it wasn't me. But on the flip side, yes, as the defense, you're going to take advantage of that and exploit that to him saying, I may have been thinking about it, but I didn't go through with it. And this was me, like, acknowledging that to my cousin or nephew rather. And my nephew said, yeah, you didn't do it, bro. So I think that there's two sides the way you can flip it. I think the more logical one, though, is that he probably realizes that, eventually people are going to be listening to his conversations and he's just saying I didn't do it.
Yeah, probably. In the opening statements, the prosecutor was talking about how he kind of thought, and you even heard him in those conversations say, basically no one's going to find her because she would disappear for like 3 days. And so he thought, these were the recordings, that maybe if they didn't look for her for a few days, that no one eventually would see that she was in the ditch. I mean, you did hear him allude to that in those conversations.
You did, and no one would look for her here, and she's not going to be missed. I think that, or, if they don't find her within, I think he said 48 hours, they're never going to find out what happened. I love these people that watch way too much, like CSI or whatever, they can get away with things like this. Those were just illogical comments, too. I mean, yes, they're going to look for her, and now, right exactly where you say you're going to put her, there she is in a ditch. And so, that is another, really good piece of circumstantial evidence. While they don't have a gun and they know that he didn't, that she didn't die by gunfire. And I guess the cause of death is kind of unknown, maybe. I'm not clear on that. But there is good evidence connecting him to it, even though he didn't follow through with his method of the crime. Everything else lines up.
Yeah, it really does. And this one I'll ask you in real quick response to this. You see him sitting there. You hear all this evidence against him. It boggles my mind defendants can just sit there when there's all this evidence against him and not stand up and be like, okay, you know what, I did it. But, Krista, the facts are it's the prosecution's burden to prove a case. You are, as a defendant, presumed innocent.
Yeah, and you get a defense paid for if you can't afford one. And so I think that it is, it's your obligation as a prosecutor, it's your burden, and you have certain things you have to do, and so that's what's happening here.
Yeah. Krista, thank you so much. Always great to see you and great to hear your insight. Coming up, more of the defendant's conversations with his nephew in the pregnant mistress murder trial. We'll be right back.
Granger.com or just stop by. Granger, for the ones who get it done.
Welcome back to Court TV Live. I'm Kelly Craft, in today for Ted Rollins, along with Julia Janae. And we are in Florida this afternoon for the pregnant mistress murder trial.
That's right. The defendant here is Jose Soto Escalara. He is facing the death penalty if he's found guilty of murdering his pregnant mistress. This all happened back in 2018.
Prosecutors say the father of 4 gave 23-year-old Tanya Wise $500 to get an abortion, but when she refused to follow through with it and threatened to tell his wife, Soto Escalara allegedly killed her.
And what we're listening to right now inside the courtroom is really important. This is how the prosecution led their opening statement in front of this jury. It's recorded conversations that were said in Spanish and then translated, so they're in a transcript, and we're hearing different individuals, an interpreter as well, being able to share this with the jury. You hear unintelligible a lot for things that they couldn't make out. But this is a conversation, allegedly, that the defendant had with his nephew.
She was in the water, submerged in the water. No one knows how she was killed, but unintelligible.
One of her friends dances.
Yeah.
Unintelligible.
You see session 32 of 39?
Yes.
On what date does that fall?
August 27th, 2018. Did you call unintelligible?
So, do I call unintelligible? Call from your telephone. What happened? What's the deal? What happened? What? All right. Yeah, okay. No, that's fine. I already told the cops what I had to tell. All kinds of shit. Don't worry about it. Don't worry about it. No, because I didn't do nothing. I didn't do anything. Yeah. Tell the truth. Yeah. No, that's fine. Don't worry about it because I already told them everything I had to tell them. So you know what I'm saying? I ain't lie about nothing. I didn't do nothing anyway. So yeah, they already talking. Unaudible. Yeah. Huh? No, we're good. I ain't got nothing to hide. All because they don't want to be involved. No, I don't got no alibi.
Huh?
Now, I don't got no alibi. I'm not going to worry about it. I didn't do anything. I think this little jerk did something. That unintelligible.
And you see session 33 of 39?
Yes.
And on what date is that?
August 27, 2018.
Huh?
Unintelligible.
Why?
I told you unintelligible.
Exactly. And I, unintelligible. I didn't do anything. I didn't.
And you see session 34 of 39?
Yes.
On what date does that fall?
August 27th, 2018. Should I answer?
What's she want?
Unintelligible. Call.
Huh?
Your sister is calling me.
My sister called you?
Yeah.
Oh.
Unintelligible.
Huh?
I can't take this thing home. Unintelligible.
Yes, you can. You have to do it. They're going to take me, and they aren't going to see anything. Hide that one. Go in there a little and hide it really well. They won't. They aren't going to take you.
They can't take you to jail, bro.
Huh?
They can't take you to unintelligible.
The hell with it. Unintelligible did it.
They can't do anything, bro.
And do you see session 35 of 39?
Yes.
And on what date does that fall?
August 27, 2018. I told you unintelligible, brother.
Oh, I know. That. It's everything you are saying has happened, but there's no proof because I didn't do anything.
Oh, man.
And do you see session 36 of 39?
Yes.
On what date does that fall?
August 27, 2018.
They don't have anything.
You see session 37 and 39?
Yes.
On what date does that fall?
August 27, 2018.
Take care of your family, bro. Remember that. I'll be fine.
Unintelligible.
Write to me if anything comes up. You're going to be fine. I know somebody was going to set me up. I knew it, bro. But there's no way. No way, bro. I'm not going to let nobody set me up, bro. There's no way. There's no way.
Do you see 38 of 39?
Yes.
Date? What date?
August 27, 2018.
I'm already calm. Do you hear me?
Huh?
I'm already calm.
Okay, and do you see the final session 39 of 39?
Yes.
And on what date does that fall?
August 27, 2018. This is a conversation with an unknown male.
Okay, go ahead.
Stating the objection, the jury should disregard the last.
Okay. Go ahead. We'll go.
Huh?
What?
I got to go back to the police station.
Again?
I feel like I'm being set up.
Thank you. Commissioner excuse me. Commissioner Approach?
Surreptitious recordings are always tricky inside of a courtroom, and that's what we're seeing play out in this one. Let's bring in our guest for this hour to join us. From Austin, Texas, we have criminal defense attorney and former prosecutor Lindsay Richards with us. Lindsay, thanks so much for joining us. Tell us what you think about these recordings. This is something that it seems that the defendant did not know was happening. His employer was recording the garbage truck that he drove. He's on the phone with his nephew. The jurors don't know for sure if it's his nephew, but they are, through other witnesses, going to have that voice identified.
It's been very interesting. It is kind of hard to follow the conversation, to be perfectly honest. It's hard to kind of know. It's almost like they're speaking in code. You can't quite tell what they're discussing and how they're discussing it all the time. You know, I think this is evidence that is vital for the prosecution because in order to seek the death penalty, they need to prove some sort of premeditation. And I think this seems to be so far the only real evidence that they've introduced to show that. So I think that's a super important piece of evidence for them. But there's a lot of unintelligible, and there's also a lot of I didn't do anything wrong, which could be argued is really him just kind of freaking out about this affair, about this baby, and not necessarily about the offense itself.
You know, Lindsay, what we're hearing is that they are now going to be playing these recordings in Spanish for some of the jurors. So defense counsel made an objection, and because of that, now the judge is letting the recordings be played, at least portions of them that are in Spanish for the jurors. I was just taking a look at the jury makeup, and it does appear, so 12 plus 4 alternates, it does appear there are about 5 or 6 people that are Hispanic that are on the jury. So they would be able to understand that and maybe get a more complete understanding of those parts in which they say things are unintelligible.
Well, and I think it's important to, tone, inflection, the way things are said matters. And so at least hearing that could be very beneficial. However, it's also a little bit unfair that some jurors would be able to fully understand what is being said and others may not. And typically you don't want one juror having more knowledge about evidence presented than another, or explaining in the jury room, oh, this is what I heard and this is my perception of it, as opposed to everyone hearing the same piece of evidence. So it is surprising to me that it's being let in, that he's allowed to play the actual audio recordings with some potential Spanish speakers on the jury who would have better understanding of a piece of evidence.
Yeah, that could be very interesting in the deliberation room. We don't know how many of those jurors do speak Spanish fluently or otherwise, but that it really could change up things.
Yeah, good point, Lindsay. Thank you. All right, coming up, we are going to switch gears. We're going to head to our other live trial. This one's out of Florida as well. This is a man accused of drugging and then strangling his husband. That's coming up next.
Saturday nights on Ion.
It's our night.
Let's go! Double headers every Saturday at 7 and 10 p.m. Eastern. The new Saturday Night Out is on Ion all season long.
A young mother found brutally murdered.
Now the victim's boyfriend, a married father of 4,
Is charged for the murder of his alleged mistress and her unborn child.
The Pregnant Mistress Murder Trial. Live coverage today, only on Court TV.
Turning now to another trial that we are following out of Florida, the dosed and choked murder trial. This one is for Herbert Swilly.
Yeah, he's a 57-year-old contractor. He's accused of killing his husband of nearly 8 years back in March of 2023.
And prosecutors say that Swilly drugged and strangled Tim Smith. This was in their home and then moved the body to an apartment that they owned where he staged a fake crime scene.
Yeah, it's an apartment where the couple would have sex with other people in this open marriage, and the defense is trying to say that perhaps someone else is the one who killed the victim here. Let's give you a background on this case before we go into live court. Here's more on the case against Herbert Swilly.
Tim Smith and Herbert Swilly seemed to be a loving couple. They'd been married nearly 8 years when the unthinkable happened. After he didn't show up for work, Smith was found dead in an Ocala, Florida apartment in March of 2023. Police say Smith had been drugged, beaten, and strangled. His sister spoke with local station West News.
My brother's not a small person, or wasn't. He was tall, and he was strong, and I can't imagine what he went through, and it breaks my heart to think of it.
Swilly posted on GoFundMe announcing Smith's funeral and reportedly raising a couple $1,000s on the platform. Swilly also stood to receive more than $300,000 from a life insurance policy on his husband.
Just from the first initial conversation I had with him, he changed his story in that conversation 3 times.
After a months-long investigation, deputies arrested Herbert Swilly, charging him with the murder. Investigators say Swilly drugged Smith and strangled him with a ligature at the home the couple shared, and then drove his body to a secondary apartment the couple had, where investigators say he staged a fake crime scene. According to the arrest warrant, Swilly told police the couple had an open marriage and used that apartment for sex with other people they met on social media. Swilly has pleaded not guilty to the murder of his husband.
Let's get into the courtroom now for the state's first witness of the day. This is a bookstore employee.
Did a man come into the store to donate some items of his deceased husband?
Yes, he did.
Do you see that person in the courtroom today?
I do.
Can you please point to him and describe something he's wearing?
Yes, he's over there in the blue jacket.
In the middle?
Yes.
Your Honor, may the record reflect the witness has identified the defendant?
It will so reflect.
And how did that transaction happen?
The gentleman, he came up to the side of the porch with a box full of books, and he had called earlier that day to ask if we took donations, and of course I said yes, we do. He came in, and I was sitting on the porch at the time, and he had the box of books, and we exchanged greetings, like hello. Are you Amy? I spoke to on the phone. Here's the box of books, and he was just very guarded. And I was able to take the books from him at that time.
Did you ask him any questions about where the books came from?
Yes, I asked him just like, oh yeah, you know, like what's going on with this, like, and he said they were his husband's, and at that time, I was like, oh my gosh, I'm so sorry, what happened? He's like, he died. And I was like, oh my gosh, when? And I'm just saying this out of empathy because I've lost family members. And he was like, this weekend. And that really stood out to me, that it was so quickly after your partner dies to be getting rid of their stuff almost immediately.
And was there any more discussion between the two of you?
Yes, we went back and forth a little bit. He mentioned that his excuse was that or he said that his daughter wanted to get rid of the stuff, was trying to get rid of it all, and just kind of, sorry, went back a little bit about that.
All right. So there was a little bit of back and forth about...
Yeah, just like general, like chit-chat a little bit, you know, I was trying to be nice and talk and, you know, be understanding of someone that just lost someone.
And Did he leave after that conversation?
He did, yes.
All right.
He left the books with me and he left.
All right. And what happened after he left and he left the box of books with you?
So he left the box of books with me and I'm sitting there on the porch and I start to go through them and there's some books and there's some like tarot cards and stuff of that nature in there. And I started going through and sorting everything and I noticed there were some journals in there as well, which happens sometimes, and there'll be blank journals we could resell. So I go and I go to open them and look through them to kind of see if they were blank or not, if there's something we could use. And I see that they are written in. There's more than one journal. They're like fully written in. And in one of them, tucked in like a bookmark, was a photo strip, like from a photo booth. And there was a picture of the defendant, and as well as what I assumed to be his husband at the time. And the person in the written the journal was the husband as well.
Right. And was that a problem that it was journals that were written in? Were you able to resell a journal?
No, of course not. Yeah, so that was just something I set aside.
All right. And then, so what did you do after you sorted out the books and you saw that the journals were written in and there was a strip of photographs? What did you do after that?
So I was just kind of, still pretty normal at that point. Had the stacks of books and, just sorting through things, counting the tarot decks to make sure everything was there, stuff of that nature. And I took a little bit of a break and I sat back and opened my phone, and I opened Facebook, and there was a notice from the sheriff's office with a picture of the other man in the photo strip that I had just seen in the book. Yes.
And this was from the Marion County Sheriff's Office?
It was from the Marion County Sheriff's Office Facebook, and it had his picture, and it said, if you have any information, please call. This man was murdered over the weekend.
All right. Did it have the man's name in the Facebook post?
Yes.
It was murdered?
Yes.
Okay. And was that man's name Tim Smith?
Yes, it was Timothy Smith.
Okay. Was that name in any of the journals that you had looked at?
Yes, the name Tim was in there.
All right. So the journals had the name Tim and his picture was in the strip?
Yes, it was very obviously his picture.
All right. Did you call the sheriff's office that day in response to the Facebook notice?
I did not call that day.
Why not?
It was one of those things that it set wrong with me, but I was kind of just like, this is too weird to immediately call. And I went home and slept on it. And I called first thing the next morning. I called not the hotline, but I found the detective's contact information and contacted him directly.
All right. And did you actually meet with the detective that day that you called?
Yes, he came to the store.
All right. And did he take everything that the defendant had brought?
Yes. No, he didn't take everything.
Okay, what did he do?
He went through the box and I showed him the journals. He took photos of everything. He took my statement of what had happened with my meeting with him, and then he took the journals with him.
All right. The journals that had the writing in them?
Yes.
Okay. And then he left the books and the tarot cards?
He left the books and the tarot cards, yes.
Right. And was the defendant alone when he came in and brought these things?
Yes.
Did you have any other interaction with the defendant?
No.
Your Honor, may I approach the witness?
Yes, ma'am.
I'm going to show you what's been marked for identification as State's Exhibit SS. You can look at these 4 photographs and tell me if you recognize those.
Yes. Yes, these are the books that he brought in. Yes. And those are the journals. And that's the photo strip and the page that I found it on.
Are those pictures fair and accurate depiction of what the defendant brought in that day?
Yes.
Your Honor, at this time, we would move State's Exhibit SS into evidence.
No objection. Can I see it?
Yes.
States SS, what's the next number? Will be in evidence of states number 50.
And Your Honor, may I publish?
Yes, ma'am.
I'm showing you photograph number 1 of States 50. What are we looking at in this picture?
Those are some of the books in the original box that he brought in.
All right. And photograph 2 of States 50.
Those are some of the books that I started to remove because the handle on the box was ripping.
And photograph 3 of States 50.
Those are the 2 journals that were written in.
And had the name Tim in them.
Yes.
And then photograph number 4.
That is the photograph with the photo strip from the photo booth that was in the journal.
Thank you. I don't have any other questions.
Any cross-examination?
No, Your Honor, no cross.
Is he excused?
Yes, we'd ask that she be excused.
Have a nice day, ma'am. Thank you very much.
State will call Mike Aguiar.
You have a different name up there. It's okay. How do you spell Aguiar?
Aguiar.
All right, well, they got to pause there in the courtroom. Let's slip in a break. But gosh, this witness sounds like something out of a mystery novel. A bookstore employee just finds journals and a photo strip and then connects it to what's on Facebook and calls police. Let's get to our break. We're going to hear more after this in the case against Herbert Swilley. we'll get you back to the courtroom there in Florida in just a moment. But first, we do want to give you some developments in the Mastermind Matriarch murder trial, where Donna Adelson's defense has requested a new trial, and they're claiming juror misconduct.
Adelson was found guilty by a jury of 12 earlier this month, and since then, several jurors have come forward to talk about their experience. Donna's motion for a new trial asks the court to allow her to interview some of those jurors, including the foreperson.
Yeah, juror number 7 posted several videos to TikTok after the verdict, and she said she did post during the trial, but not about the trial. But Donna Adelson's motion alleges that some of her posts during the trial may have been in violations of the court's instructions, and the foreperson denied ever posting about the trial itself.
The state and judge have not yet weighed in on this motion. We will keep you posted with the details.
But back now to another Florida case that we're watching. It's a live trial. Defendant Herbert Swilly is accused of murdering his husband, Timothy Smith.
Prosecutors say the marriage was on the rocks, and Smith was planning to leave Swilly. They say that Swilly could not afford to keep up with his lifestyle without his husband's income, and he wanted to cash in on Smith's life insurance after his death.
Now, we just heard from a bookstore employee who said that very soon after this death that Swilly was giving away his husband's journals and books. The next witness is a man named Lloyd Kelly, someone who was involved with the defendant and the victim. Let's get you back into the courtroom.
Good morning.
Good morning.
Can you please state your name for the record?
Lloyd James Kelly.
A little bit slower and louder, please.
Lloyd James Kelly.
Thank you.
I'm sorry, I got it.
No, that was fine, thank you. Where do you currently live?
Virginia.
How long have you lived in Virginia?
Total of about 12 years, but this time about a year and a half.
Where were you living before Virginia?
Summerfield, Florida.
I'm sorry? You're just cutting in and out. If you can repeat.
Summerfield, Florida.
All right. Thank you, Summerfield.
Yes, ma'am.
And are you employed?
I am.
What kind of work do you do?
Heavy construction worker, heavy equipment operator.
Are you currently on probation?
I am.
What are you on probation for?
Driving unsuspended and possession of methamphetamines.
Driving on a suspended license and possession of methamphetamine.
Yes, ma'am.
All right. Did you originally get put on probation in Florida and then have it transferred to Virginia?
I did. The only reason I was in Florida was because my mother had stage 4 cancer, and I went down there to take care of her and the house and everything.
Sorry.
Mr. Kelly, listen carefully to me. Please don't volunteer any information. Just answer the question exactly how it's asked, okay?
Yes, sir. I understand.
Thank you.
I know you already alluded to this, but I want to direct your attention to March of 2023. You were living in Florida at that time?
Yes, ma'am.
All right. And where in Florida were you?
Summerfield, Florida.
And with whom were you living at that time?
I was taking care of my mother, and my wife was there.
Now, during the time you were taking care of your mother and living at her house, were you using different apps to meet men and women for anonymous sex?
Yes, we were.
All right. And you said we. Who's we?
Myself and my wife.
And yourself and your wife?
Yes, ma'am.
All right. And was Grindr one of those applications you were using to meet people?
Yes, ma'am.
And where would you meet with the people that you met on Grindr?
Before my mother passed, it would generally be a hotel.
Did you ever go to a quadruplex in Marion County with 2 bedrooms? One of the bedroom had a sex swing and a massage table in it?
No, ma'am.
All right. I'd like to show you 2 photographs. First photograph states 5, photo 27. All right. And do you recognize that bedroom?
Not at all.
All right. And then I'd like to show you states 18, photo 7. Do you recognize that room?
No, ma'am, I don't.
All right. And now I'd like to show you states 4. Do you recognize the person in states 4?
I do not.
And then I'd like to show you states 2. Do you recognize this person?
I do not, other than the fact that I've been looking at being showed pictures and looking it up online. Other than that, no, I don't know that person.
Is it possible you had a sexual encounter with this person?
I would have remembered.
At that time, were you having sex with people just one time and then never again?
Yes.
Now, when you would meet people for anonymous sex at the hotel during this time, would it be unusual for people to bring lubricant?
Not unusual at all.
Okay. Did that happen regularly?
Yes, ma'am.
Did you meet with Tim Smith, the last person that we saw the photograph of, on Thursday, March 23rd of 2023?
I think I would remember.
You don't remember meeting with him?
Not at all.
Did you kill the person that you saw in the last picture, Tim Smith?
Absolutely not.
I don't have any other questions, Your Honor.
So we have some additional questions on cross-examination. Please listen carefully to the questions, okay?
Yes, Your Honor.
Good morning, Mr. Kelly. Can you hear me okay?
Yes, I can, sir.
My name is John Klein. I'm the attorney for the defendant. Have a few questions related to the direct examination you just did with the prosecutor. You mentioned that you're currently on probation, correct?
Yes, sir.
Have you ever been convicted of a felony, sir?
Yes, sir.
How many times?
I think 3.
Okay. Yes, sir. And when you and your wife were helping to take care of your mother here in the state of Florida, what period of time were you here for? Do you recall?
Approximately a year and a half. If you talk about my incarceration, I was in South Carolina.
Right. You were in the Sumter County Jail as of March 29th, 2023, correct?
Yes, sir.
Okay, but prior to, before March 29th of 2023, you were not in jail and you were with your mother in Florida, correct?
Prior to that, I was incarcerated in Marion County Jail due to a U-Haul incident. I had rented a U-Haul. My mother had passed, and I forgot to take it back. It sat in the backyard behind the garage, and they tried to get me for stealing that, but that was all dropped.
When did you get out? When did you get out of the Marion County Jail?
I don't have that in front of me, sir. You're talking a couple of years ago, and I don't have that paperwork in front of me. I can't give you exact dates.
Okay, but
there, record.
I understand it's been some time. That's fair, but you would agree with me that there was a period of time between when you got out of the Marion County Jail and when you went back into jail in a different county, Sumter County, on March 29th, 2023, correct?
I can't give you exact dates, sir. All the dates are a matter of record.
I understand that. So you don't know?
I don't have the exact dates in front of me. I can't tell you positively.
Understood. Your Honor, I have no further questions.
Ms. Barney, redirect?
No, no further questions, Your Honor.
I thank you, Mr. Kelly. You're excused, okay?
Sir.
Thank you.
All right, the witness is excused. Let's bring in criminal defense attorney and former prosecutor Lindsay Richards. Lindsay, At this stage, a juror may be scratching their head to wonder why this witness was even called if he denies even knowing any of the parties. But there is more to come, and it's going to involve the DNA expert that's going to testify. But your thoughts on what we heard just from this testimony?
My thought mainly is I'm wondering why they set it up this way with the introduction of this witness before introducing the investigation and the DNA to show why this is even significant. Certainly, it seems like the defense is going to be there's alternative suspects. They were engaging in, kind of an open relationship and meeting up with random people from the internet. So we should have heard first, has there been an investigation into these alternative people, and do we know who he was talking to, who potentially could have been there besides this defendant, and meeting up with him, and then potentially had the testimony of Mr. Kelly. Because right now it's confusing. It's confusing, I would think, to a jury.
Lindsay, is there anything else you would have done on cross? They were talking about, past convictions, trying to attack his credibility, even though I don't even know if you needed to do that. Is there any other approach you would have taken from a defense's perspective?
I think attacking his credibility certainly is the number one strategy on any cross-examination. But also, just having him answer the question, did you kill him? And he's going to say no. Of course. Did we think that anyone, even if he did do it, would get up there and be like, yep, it was me? Of course not. So it's, I may be asking those questions and a little bit more pointing out the kind of absurdity of even asking that question to begin with. And that certainly this person's not going to admit to that.
Mm-hmm. Lindsay, thank you. All right, we're going to squeeze in a quick break. When we come back, we're going to continue to follow this case that we've been watching. It's definitely an interesting one, hearing about all of their lives and everything else going on. We'll be right back.
My two best friends were just murdered.
Join me for a Court TV true crime series where we take you from the crime scene to the courtroom.
Donna Adelson hates every piece of grass that Dave Marcel ever walked on.
It's something that'll haunt all of us forever.
It always seemed like he was covering or deceiving.
This was a whole different level.
Victim to Verdict with Ted Rowlands, a Court TV original series. Season premieres September 27th.
Only on Court TV.
Back to Ocala, Florida now, where a man is on trial for the 2023 murder of his husband.
Defendant Herbert Swilly faces first-degree murder charges in the death of his husband, Tim Smith. Now, deputies allege that Swilly drugged Smith, strangled him, and fractured his neck before driving his body to the couple's apartment and staging a crime scene.
Now, that crime scene, they collected a lot of evidence. Let's go back into the courtroom now. We've got a new witness on the stand who can give the jurors a lot more information. Forensic DNA analyst Lisa Johnson.
My name is Lisa Johnson, Lisa Johnsson.
Where do you work now?
Hold on 1 second. Ms. Johnson, please. Rick, gotta take your glasses off the top of your head.
Sorry.
Thank you.
Where do you work?
I currently work at the Wake County Bureau of Forensic Services
Where is that?
in Raleigh, North Carolina.
What do you do for them now?
I am a forensic DNA analyst.
Where did you work prior to that?
The Florida Department of Law Enforcement in Jacksonville.
And what did you do for Florida Department of Law Enforcement? We call it FBLE.
I was a senior crime laboratory analyst in the biology section.
What did you do on a day-to-day basis as a senior analyst?
My main responsibilities were examining items of evidence for the presence of body fluids or other sources of DNA, develop DNA profiles from those items of evidence, and then compare the evidence samples to known samples collected from individuals associated with the case.
How long did you do that type of work for FDLE?
Just over 12 years.
Can you describe for the jury your educational background and your training that allows you to do that type of work?
I have a Bachelor of Arts degree in Interdisciplinary Natural Sciences from the University of South Florida and a Master's of Science degree in Forensic Science from the University of Alabama in Birmingham. The first year or so that I was with FDLE, I went through their analyst training program, which was consisted of literature readings, textbook readings, becoming familiar with the protocols and procedures in place within the laboratory, working on practice samples. I also did written and oral examinations and supervised casework where I examined evidence under the supervision of a qualified analyst. And then I finalized it with a mock court type situation.
And how long have you been a DNA analyst in total?
Almost 20 years.
Okay. Do DNA analysts at Florida Department of Law Enforcement undergo proficiency training and testing and things like that?
Yes.
And did you do that when you were there?
Yes.
Were you successful in doing all your proficiency testing?
Yes.
All right. Have you ever testified in court regarding the field of forensic serology or DNA testing or statistical analysis and DNA testing, those types of areas?
Yes, I have.
Can you estimate about how many times?
Over 160.
Okay. Can you describe for the jury provide the jury a very general explanation of what DNA is and how you use it?
Yes. DNA is a substance in our body that makes us unique individuals. Greater than 99% of everybody's DNA is the same. Only identical twins have exactly the same DNA. We inherit our DNA from our parents, so we get half from our mother, half from our father. And it's the same throughout our body, so blood, skin, all the same DNA, and it doesn't change over the course of our lifetime. So that allows, in my field, a sample that's left behind to be tested and compared to see if evidence left behind could come from an individual based on the DNA profile that's obtained.
Can you describe for the jury the process you go through when conducting a DNA analysis?
It's a 4-step process. The first step is to remove the DNA from whatever it's on. So if it's on a swab or a piece of clothing, the extraction process removes the DNA from not only what it's on, but also from the cellular material that it's contained within. The second step is to determine how much DNA is in that sample. The third step is, it's called the amplification, or the area where we're targeting 21 specific locations on the DNA and making copies of those so that they can be visualized and compared. And then the final step is that visualization or the determination of the DNA profile, which represents as peaks on a graph. And it's the location of those peaks on the graph compared from evidence to known samples that allow me to determine if it's a same source or not.
Does that 4-step process you just described do anything to alter or change or modify the actual DNA?
No, it does not.
And what are controls?
Controls are items within our testing process that are used to make sure that everything is working properly. So for the extraction step, there's a blank sample or a negative control. And that simply is a sample that does not have any DNA in it. And that goes through the entire process to make sure that none of the chemicals that I'm using or there's no cross-contamination between any samples getting DNA into that particular sample. So it's just showing that everything is coming back clean. And then in that amplification step or that copying stage, I do a positive control and a negative control. So we have a secondary negative control, again, showing that everything is clean. The positive control is a known DNA sample. So that gets processed to verify that the results that I'm obtaining at the end are correct so that I know that the instrument's working properly and everything worked as expected in the run.
Is it also normal in your course of work as a DNA analyst to perform statistical analysis to give meaning to your DNA results?
Yes.
And are you're trained in how to do that?
Yes.
Have you provided testimony in court regarding that statistical analysis?
Yes, I have.
This time, Your Honor, the state would request permission to allow this witness to provide opinion testimony in the area of DNA analysis.
No objection. Any voir dire?
No voir dire.
I'll allow her to testify in the form of an opinion without objection.
When you were working at Florida Department of Law Enforcement, did you and your laboratory receive some evidence in the case of State of Florida versus Herbert Swilly?
Yes.
Were you provided a DNA standard from Herbert Swilly?
Yes.
And what is a DNA standard?
It's a sample collected directly from an individual, so it's a known DNA sample collected from a person. Typically, it's a scraping from the inside of their cheek.
Showing us when introduced into evidence of State 17. You recognize that item?
Yes.
How do you recognize it?
The bright yellow barcode is the FDLE case number, item number, and then in my handwriting, again, the FDLE case number, the item number, my initials, and the date that I opened this item.
Did you analyze that known DNA standard from Herbert Swilly for the presence of DNA?
Yes.
Did you use the same process you just described to the jury?
Yes.
And what were your results?
I developed a complete profile. So
what's a complete profile?
Sorry. So like I said, we're looking at 21 different locations on the DNA. So in this case, I obtained results at all 21 locations. So that's all of the information available for my testing that I could obtain from that item.
Showing you what's been marked as State's Exhibit Triple B. Do you recognize that?
Yes.
How do you recognize it?
Again, the bright yellow FDLE barcode with the case number, item number, and then in my handwriting, the FDLE case number, item number, the individual items contained within this package, and then my initials and the date that I opened that item.
What is that item?
It's a sexual assault kit.
Okay. And during the course of, is that usually collected during the time of the autopsy in a case like this?
Yes.
Okay. And during that collection of the sexual assault kit, were samples taken from the subject's mouth?
Yes.
And did you use those samples as a known standard for the victim, Timothy Smith?
Yes, I did.
Did you analyze those known samples from the cheek swabbing of Timothy Smith as a known standard for him?
Yes.
Did you analyze it for the presence of DNA?
Yes.
And what did you find? What were your results?
That was again, it was a single source profile, a complete DNA profile. So I have
We want to thank our guest who is joining us this hour, Lindsay Richards. And coming up next, we're going to continue to follow this case, and it definitely is an interesting one to say the least. We'll be right back.
Welcome back to Court TV Live. I'm Julia Janae, along with Kelly Craft, who's here filling in for Ted Rollins. Thank you so much for being with us as we begin this hour. In a trial where a man is accused of killing his husband.
57-year-old Herbert Swilley is accused of drugging and then strangling his husband, Tim Smith. This was in their home back in 2023.
Now, prosecutors say that Swilley then moved his husband's body to an apartment that the couple used for sexual encounters with other people that they met online, and that he then staged a fake crime scene.
Let's get you back to that courtroom now. The jury is hearing from a forensic DNA analyst, Lisa Johnson.
A complete profile from both of those individuals.
Showing what's been introduced into evidence of States 43, did you also receive a known DNA sample from someone named James True?
Yes.
Do you recognize that item?
Yes, I do.
The same way you previously described?
Yes.
All right. Did you analyze that item for the presence of DNA?
Yes.
And what did you find?
A complete DNA profile.
Okay. So at this point, now that you have a complete DNA profile from Herbert Swilley, Tim Smith, and James True, are you able to take those known DNA profiles and compare them to other evidence collected from a crime scene to see if it's consistent?
Yes.
Were you in fact provided various pieces of evidence, mostly in the form of swabs, collected by the crime scene investigators in this case?
Yes.
Is it normal for you to receive a swab collected by a crime scene investigator from an item rather than the actual item itself?
Yes, specifically with Marion County, their crime scene does a lot of their sample collections, and they swab items and then just submit the swabs to us.
Okay. Does that affect your analysis in any way?
No.
You mentioned in front of you the sexual assault kit, State's Exhibit Triple B. What items are contained in that you've looked at?
There were anal swabs, scrotal swabs, penile swabs, obviously the oral swab that I used for comparison, and pubic hair combings. There was also pulled pubic hair. Yes, I know those were the 6 items within
And
that.
are those the normal things you see in a sexual assault kit?
Typically for a male kit, yes.
Okay. Were each of those items that you mentioned individually packaged inside of that larger item?
Yes.
Did you analyze the other items in that sexual assault kit for the presence of DNA? Some of them.
Some of them, yes.
And we'll get into the individual ones. Did you use the same procedure you just described?
Yes.
What specific items did you analyze in that sexual assault kit for the presence of DNA?
The anal swabs, scrotal swabs, and penile swabs.
When you analyze those types of things taken from a sexual assault kit, do you assume that the victim's DNA is going to be on those things?
Yes, since they're collected directly from that person's body, I would expect during the process of collection, their DNA would be present as well.
So when you were analyzing those types of items for the presence of DNA, are you really looking for foreign DNA or DNA that does not belong or match the victims?
That's correct.
Referring to the anal swabs, when you analyzed that item for the presence of DNA, what did you find?
I developed a DNA profile that was consistent with a mixture, which just means there was DNA from more than one person within that particular sample. I would expect Timothy Smith's DNA to be present, and it was. And then the results that were foreign to him were too limited to do any type of comparison.
And what does that mean?
Like I said, we look at 21 different locations. In order to do any type of comparison or interpretation, we need at least 7 types to make that type of comparison. So in this case, there were fewer than 7 types present within that mixture that would have come from somebody other than Timothy Smith.
So basically the amount of DNA was just so minimal you couldn't do anything with it.
That's correct.
So I'm assuming in real life, not like Crime CSI on TV, you can't get DNA from everything you look at.
That's correct.
Referring to the, I believe, the scrotal swabs, did you analyze those for the presence of DNA?
Yes.
What did you find?
There were no results foreign to Timothy Smith on those swabs.
And what about the penile swab?
It's the same thing.
You mentioned in that kit there were pubic hair combings collected from the victim. Did you analyze those combings in any way?
I opened the package and there were no visible hairs present.
Since there were no hairs present, could you do anything with it as far as the DNA analysis is concerned?
No.
Showing you State's Exhibit 12, did you receive some swabs taken from the fingernails of the victim in this case?
Yes.
Did you analyze those swabs for the presence of DNA?
Yes.
What were your results?
The left and the right were, I examined them separately. There were, again, mixtures of multiple individuals, but the foreign donor or the person not Timothy Smith was too limited to do any type of comparisons.
Again, the amount of DNA was just too minimal for you to analyze.
That's correct.
I understand. Showing you State's Exhibit 11, where you also provided fingernail clippings taken from the victim.
Yes.
Did you analyze those clippings for the presence of DNA?
Yes, I did.
What'd you find?
On the fingernail clippings, there was no DNA foreign to the victim.
Showing you State's Exhibit 13, did you analyze some DNA or some swabs collected from various portions of the victim's body for the presence of DNA?
Yes.
And what were your results?
For the, sorry, real quick. There was a swab from the lower right leg. There was not enough results at all to do any type of comparison, so not even Timothy Smith's DNA. On the swab from the left leg and the left arm, it was the same. There was limited amount of DNA, so I could make no comparisons whatsoever.
Showing you State's Exhibit, first of all, I'm going to show you photograph 34 from State's Exhibit 5, where you also provided swabs taken from the black shirt the victim was wearing.
Yes.
Did you analyze those swabs for the presence of DNA?
Yes, I did.
And what were your results?
There were, again, there was a mixture obtained. The foreign contributor was too limited to make any type of comparison.
Showing you State's Exhibit 36, where you provided a swab collected from the victim's left shoe.
Yes.
Did you analyze that as well for the presence of DNA?
Yes, I did.
And what were your results?
Give me just 1 second. I gotta refer to my notes. Again, there was a mixture, but the foreign results were too limited to make any comparisons.
What do cleaning agents like bleach do to DNA?
Cleaning agents will wash it away, and it can also degrade DNA to make it so that it's not detectable.
And in your DNA analysis, would you be able to determine that a DNA sample provided had bleach in it?
No.
Okay, why not?
That's not something that we can test for.
Understood. Showing you photograph 3 from State's 18, did you receive a DNA swab collected from a coconut juice can in the garbage can at the scene?
Yes.
Showing you State 20, did you analyze that item for the presence of DNA?
Yes, I did.
And what were your results?
There was a mixture consistent with 2 individuals, at least one of which was male. Timothy Smith, Herbert Swilly, and James True were all excluded as contributors to that profile.
Okay, meaning Timothy Smith, Herbert Swilly, and James True did not contribute to the DNA found on that swab?
That's correct.
Okay. And you said at least one of the contributors was male. How do you know that?
In addition to the 21 locations that I look at in terms of DNA comparison, there's 3 locations that determine gender. And in this case, there was at least one marker consistent with there being a male individual.
Showing you photograph 29 from States 5, as well as item number 35 introduced into evidence. Did you receive a DNA swab collected from a bottle of gun oil lubricant?
Yes.
What did you determine when you analyzed that for the presence of DNA?
There was a limited amount of DNA on that item.
Now,
All right, listening to the DNA analyst on the stand, we are going to squeeze in a quick break, but don't go anywhere. We're coming right back. You're watching Court TV Live, your front row seat to justice.
Tonight, on closing arguments, another dramatic day of testimony in the pregnant mistress murder trial. We'll break down the biggest moments in this death penalty case.
Closing arguments with Vinnie Politan tonight at 8/7 Central, only on Court TV.
Saturday nights on ION is our night. Let's go! Double headers every Saturday at 7 and 10 p.m. Eastern. The new Saturday Night Out is on ION all season long.
Welcome back to Court TV Live. Thank you for being with us as we follow this trial out of Ocala, Florida. It's one that we're calling the Dosed and Choked murder trial, and the defendant is a contractor named Herbert Swilly.
Prosecutors say that Swilly drugged and then strangled his husband of nearly a decade in order to receive a large life insurance payout.
But the defense on the other side of this says Swilly and Tim Smith, that they had an open marriage, that there were other people that they were involved with, and then investigators overlooked those possible suspects. And we're hearing about the DNA profiles of other men that was found inside of this separate apartment that the couple used for sexual encounters.
Let's get you back into the courtroom now. We are hearing from a forensic DNA analyst who is testifying to the DNA that was found at the crime scene.
So I did a statistical calculation regarding that.
Okay, let's talk about that first before we move on.
Okay.
So Timothy Smith was included as a possible contributor.
Yes.
Describe generally how you do this statistical analysis to give meaning or weight to that finding.
I use a software program that essentially compares the likelihood of seeing that DNA profile or that mixture of DNA if it came from, in this case, Timothy Smith and 2 people that we don't know, versus the likelihood of seeing that profile if it came from 3 unknown people. So I made that calculation, and that profile, that mixed DNA profile, is greater than 700 billion times more likely to be seen if the sample contained DNA from Timothy Smith and 2 unknown people versus if it came from 3 unknown people.
Okay, so if I can clarify, it was based on that mixture, it was 700 billion times more likely that Timothy Smith and 2 other people contributed to the mixture than if 3 people, not including Tim Smith, contributed.
It's greater than 700 billion times more likely to see that profile if those were the conditions.
And would you agree that is really strong support that Tim Smith was a contributor to this mixture?
Yes.
Okay. Did you also, now that leaves 2 other people involved in that mixture, did you compare the other 2 DNA profiles found in that mixture to the known samples provided from Herbert Swilly and James True?
Yes, I did.
And what did you determine?
In those cases, there was insufficient statistical support for inclusion or exclusion for both of those individuals.
What does that mean?
Basically, we have, or FDLE has a cutoff value for kind of the gray area where there's not a whole lot of confidence regarding a person's contribution or not. And those values fell within that range. So in this case, those 2 individuals, there was not enough support to say, yes, they're there, and then there was also not enough evidence to say they weren't there. So it's kind of in that gray area.
Okay. And based on that, there's nothing more you can analyze to flush that out anymore, correct?
Correct.
Okay. Does that statistical analysis also provide percentages of the contributors to this 3-person mixture?
Yes.
How does that work?
Like I said, I use a software program to do this calculation. And basically what the software does is it goes through and determines DNA profiles for each of the 3 people. And then it gives different amounts for each person. And it looks at what the data would look like if that was true. And it keeps changing and making guesses and kind of narrowing it down until it gets to the point where if the profile is from person 1, 2, and 3 in these amounts, the data would match, basically like the expected or the ideal way that the data would look. So then it uses that type of calculation, and it determines the percentage of how much each person contributed to the profile.
So in this specific situation, since you were able to, with pretty good certainty, identify Tim Smith as a contributor to this mixture, but you weren't able to identify the other 2 contributors, would that stand to reason that the percentage of DNA in the mixture would be more Tim Smith than the other people's?
Yes,
Okay.
there was considerably more DNA from Tim Smith than the other 2 individuals.
What percentage of this mixture was associated with the known profile, the DNA from Tim Smith?
I'd have to look at my notes. I'm sorry, I got lost. Which item were we looking at?
That's fine. We are on agency item number 64 for you. State's Exhibit 24, the adult blood swab.
Right. Sorry. Item 12. Approximately 93% of the profile would be from Timothy Smith.
So of that mixture of 3 people, 93% of it matches or is consistent with the profile of Tim Smith.
Yes.
What were the percentage as far as the other 2 contributors that you couldn't even determine?
6% and 1%.
Okay. Did you also receive a swab taken from the caps of several lubrication bottles found at the apartment scene?
Yes.
And did you analyze that swab for the presence of DNA?
Yes.
What did you find?
On that item, again, a mixture consistent with 3 donors, at least 1 male.
And did you compare that mixture to the known profile of Herbert Swilly first?
Yes, I did.
And what did you find?
Herbert Swilly is included as a possible contributor to that DNA profile. The statistic is that that profile is approximately 34,000 times more likely to occur if the DNA came from Herbert Swilly and 2 unknown individuals versus 3 unknown individuals.
Did you also compare the profiles in that 3-person mixture to the known profiles of Tim Smith and James True?
Yes.
And what were your results?
Again, those other 2 individuals were inconclusive. So they were in that gray zone.
Showing you photograph 10 from states 18. Did you receive a swab?
All right, why don't we go ahead and bring in our guest this hour. In court, they're about to show a picture that we don't want to show on camera, so it gives us an opportunity to bring in our guest for this hour. That is joining us in the studio, trial attorney Miguel Custodio. Miguel, thanks so much for coming to Court TV and talking with us about this case in studio. We've been listening to DNA evidence that's being brought forth on the stand, but I want to ask you about this. So what we're taking away from this case from one of the people that have been on the ground, talking about the defendant and his demeanor throughout this trial, in particular, some of the actions of him recently while in court, and his hands are very fidgety. When you are working with someone, when you are talking with someone or inside the courtroom, talk about the defendant's demeanor, and how important that is for them to act maybe a certain way.
It's critical that you prepare your client to make sure that anything he's doing doesn't give certain signals to the juror one way or another. A couple weeks ago, I was on a jury, and I was a 4-person. And one of the things that a lot of the jurors focused in the deliberation room was how the defendant was smiling and laughing during certain parts of the victim's testimony. And that was something that really enraged them. And I thought, as a defense attorney, he should have really trained his client to act a certain way, to not be smiling, especially when it's the victim's testimony, not anybody else's testimony. It's the victim's testimony about how she got hurt, how he hit her allegedly, and he started laughing, and people really took it really bad. And so I think it's very important when you're sitting in that jury box, there's only a few things you're focusing on. You're focusing on the witness testifying and the prosecution and the defense counsel, and who else? The defendant. And obviously the clock. That's what they're all looking at. But when they were looking at the defendant, they just could not get over the fact that he was just a horrible person because he was laughing. And so it's critical that all the trial attorneys prepare their clients accordingly because the focus is on that person. It's really on that person. And trust me, in this case, they are taking note of what's going on.
And I can't get over the fact that you were an attorney being a juror. People don't know how rare that is. Most other attorneys don't want attorneys to be on their jury. Let's talk about the DNA, though, in this case. It's a little bit complicated. Who knows which of these jurors are really following all of these numbers, but we're hearing the name James True. We are going to be hearing the name Lloyd Kelly, who we just heard on the stand via Zoom. Is DNA that critical when you know the state, it's not very helpful to them because even if this defendant's DNA is there, this is his house, this is his husband, but there are foreign DNA matches. That's big.
It's big and it's tricky with this DNA evidence, right? Because you run the risk, if you're the state, of confusing the jurors. Because if you have somebody who's dry like this expert, they're gonna get bored right away. And they're gonna start hearing, oh, there's foreign, it could have been somebody else. They start thinking that, and then the defense, that's where they have to come in and start poking holes at the prosecution's argument, right? Because what's their classic argument gonna be? That the state was hastily investigating this. They only focused on one person. There were other leads that they failed to follow up on. And so this could actually play into the defense's arguments. And so the state has to be very careful with this evidence just to make sure that you're having the witness testify quick and you're out, quick and out. Because if you start really going into the details, you're gonna lose the jurors' attention, and that's not good.
Well, speaking of the details, what they were about to show in court was a sex toy that they swabbed for DNA. Let's get to our break, and when we come back, we're going to hear more of this testimony in the dosed and choked murder trial in Ocala, Florida. Welcome back to Court TV Live. I'm Julia Janae along with Kelly Craft, who's filling in for Ted Rollins. We are watching that case against Herbert Swilley in Florida. But first, we do want to give you an update about another Florida case that we have been following, the pregnant mistress murder trial.
Defendant Jose Soto Escalara is accused of killing 23-year-old Tanya Wise after she allegedly refused to get an abortion.
Now, before court ended for the day today, the jury heard from a neighbor who testified to surveillance video of the defendant's truck on the night of the murder.
Did the neighbor to your left drive a truck?
Y el vecino de su izquierda manejaba una camioneta, un truck.
Sí.
Yes.
We are stopped on State's Exhibit 166 at the 9-second mark for the record. The screen reads 8/23/2018. The truck that is where it's paused in this video in your surveillance, do you recognize that truck?
La camioneta que usted ve que está parada en este video de su vigilancia, ¿usted lo reconoce?
Objection, Judge, may we approach?
Yes.
Now, when court resumes tomorrow, they are going to be presenting more translation evidence, recordings. Let's bring in trial attorney Miguel Custodio, who's with us, to talk about that part of this case, because, Miguel, that was a huge part, that the defense is arguing or objecting to these recordings of the defendant where he is allegedly saying, here's how I'm going to get away with it. My life is over if she is revealed as my girlfriend. When I have a wife, I have 4 kids. But all of these translations, all the recordings are in Spanish, and these jurors don't have transcripts, but someone has translated it. Do you have any problem with how they're doing it in this case?
I do, and I think that's why the defense has done a really good job of making sure that their objections are very clear, laying the groundwork for a possible appellate appeal in this case if it goes against a defendant. There's always that issue of how accurate the testimony is going to be, or when it's in a different language. And so especially here, when you have a jury that's made up of some people that are Latinos, and they I'm assuming they know Spanish, and it's going to, when they hear it, they're going to interpret it a certain way, a different way than what the other people, non-Spanish people are thinking of how it's coming across. So it's something that you have to be very careful. But the state is doing a really good job, because this, the transcripts, they're damning. I mean, they are like really bad. And so I think they know that there's a potential for an appeal down the road, but I think they understand how valuable it is, and so that's why they're going forward with it.
Yeah, it's a death penalty case.
I was asking you about the defendant in the Swilley case that we were watching. Now, this defendant, when we've watched him throughout the trial, he's taken a lot of notes. He seems like he's actively participating. What do you think of that approach from a defendant?
I think that's what you want.
Okay.
Because if he's just staring into space, I think that can lead different jurors to have different interpretations. Whereas if he's just writing, I think there's not too much you can take away from that. But I did see in an earlier segment of him kind of smirking.
Ooh.
And obviously that's not good. And as I said, the jurors are locked on this person, especially when there's a transcript. They're just thinking, how could you have said this?
Yeah.
And if he's smiling or he's smirking, that does not bode well for him at all.
We will continue to keep everyone updated on that trial. Again, the jury has gone home for the day, so no more testimony. But we are turning our attention to the other live trial we have for you in Ocala, Florida. This is a murder trial that's underway for defendant Herbert Swilley.
And he's charged with first-degree murder in the death of his husband, Timothy, who investigators say was drugged, beaten, and strangled before his body was moved to stage a fake crime scene.
Let's get you back into the courtroom now. We're listening to testimony from a DNA analyst who is explaining the different kinds of matches and profiles, some of men who are not on trial here or the victim, that she located in this case.
For his statistical calculation, it's greater than 700 billion times more likely to see that profile if it came from him and 2 individuals versus 3 individuals.
So that's a much higher likelihood that the DNA in that mixture came from Herbert Swilley, one of the people in the mixture.
Yes, it's very strong support that he is a contributor to that profile.
Did you, now there's three, you said it's a mixture of three people.
Yes.
Did you compare the mixture and the DNA profiles containing that mixture to the known profile of James True also?
Yes.
What'd you find?
James True is also included as a possible contributor to that mixture. The profile is approximately 28 million times more likely to occur if he is a donor with two other individuals versus 3 unknown individuals.
Were you able to determine the percentage of contribution that each of those 3 individuals made to the DNA mixture?
Yes.
What were your results?
Let me check my notes. So the mixture proportions are 45%, 34%, and 21%.
And how did those mixtures break down based on the 3 profiles that you found?
Herbert Swilly would be the 45% donor, James True the 34% donor, and Timothy Smith the 3%, or the 21% donor, the third person. And all of the DNA within that would be accounted for from those 3 individuals.
So if those 3 people were the contributors to that 3-person mixture, there's no other foreign DNA that's unaccounted for?
That's correct.
I understand it. Does that also give pretty strong likelihood that those 3 are the people that contribute to this mixture?
Yes.
Okay.
I don't calculate that statistic. The number gets ridiculously large.
Okay.
To the point where I don't even understand what the number means. But yes, in this case, everything is accounted for if those 3 people are the source of the DNA.
Understood. And finally, you mentioned there was a second swab collected from that same sexual device, showing you states item 27. Did you analyze that swab for presence of DNA as well?
Yes.
And what were your results?
There was a limited amount of DNA, so there was not enough, there wasn't even enough DNA to do analysis.
Thank you, ma'am. I have no other questions, Your Honor.
Cross-examination, please.
Yes, Your Honor. Thank you. Good morning, ma'am.
Good morning.
Do you miss living in the state of Florida?
Not at all.
I won't take that personally.
It was 65 degrees when I left yesterday morning.
Oh, that does sound nice. So you were with FDLE for how many years?
12.
Okay. And collectively between FDLE and any other analyst experience, you have about 20 years in total experience in this field?
Yes, that's correct.
Okay. And during your time with FDLE, you were tasked with doing an analysis of multiple swabs of suspected DNA for this case and investigation, correct?
Yes.
I want to just confirm my understanding of a few of the tests that you did regarding this investigation that were of value. You had mentioned regarding the sex assault kit or the rape kit for the victim in this case that you had done a DNA analysis of the anal swabs, correct?
Yes.
And you mentioned that there did appear to you to be the presence of foreign DNA, correct?
Yes.
Okay. Meaning not belonging to the victim?
Yes.
Okay. But you were unable to identify to whom that DNA may likely belong?
Yes, there was insufficient DNA for that foreign donor to make any type of interpretations.
Okay. And regarding the fingernail clippings and or the swabs of those clippings from the victim in this case, was there any foreign DNA, meaning DNA other than that of the victim, that you were able to identify through your analysis of those items?
No, there was some foreign DNA, but I was unable to make any type of interpretation.
Okay. And was that also the case regarding the swabs that you tested that were swabs from the black tank top that the victim was wearing?
Yes.
DNA is always really important in a case. Jurors lean in a little more when they're hearing about DNA. Let's get you to a break, and when we come back, we're going to pick it up right where we're leaving off with this analyst on the stand in the case of Florida versus Herbert Swilly.
Tonight, on closing arguments, another dramatic day of testimony in the pregnant mistress murder trial. We'll break down the biggest moments in this death penalty case.
Closing arguments with Vinny Politan tonight at 8/7 Central, only on Court TV.
Join me for a Court TV true crime series.
I've never seen anything like this.
This was a whole different level.
Victim to Verdict with Ted Rollins. Season premieres September 27th.
Only on Court TV. Free.
Well, welcome back. Let's get you back inside of the dosed and choked murder trial that centers on an apartment that was used for sexual encounters. The defendant here is Herbert Swilley.
And he was arrested back in 2023 for the murder of 59-year-old Timothy Floyd Smith. This was his husband. The couple had been married nearly 8 years. Smith was found dead in an Ocala apartment after he failed to show up for work.
Now, we're hearing from a DNA analyst who's on the stand right now. She is just starting her cross-examination, and she did say during her direct that she found different DNA profiles for 3 people, so one being the victim, one being the defendant, and one being a third man. But the defense is about to spend a lot of time on a 4th man. Let's go in.
Yes, that's correct.
Okay. And regarding the swabs that you tested, which were from the coconut water can in this investigation, you mentioned, and correct me if I heard you wrong, that there was DNA from at least 2 unknown male contributors.
There's 2 donors, at least one of which was male.
I see. Okay. And James True, my client Herbert Swilley, and the victim Tim Smith were all excluded as contributors to that DNA mixture, correct?
Yes, that's correct.
Okay. And then we moved on, and this case is a bit unique. There was mention of swabs from a butt plug that you tested for the presence of DNA. Do you recall discussing that on direct examination?
Yes.
Okay. You mentioned that regarding that analysis, Tim Smith was included as a contributor to that mixture, correct?
Yes.
And that was a mixed DNA profile for 3 different individuals.
Yes, that's correct.
Okay. And one of them was Tim Smith.
Yes.
One of them was James True.
No.
Okay. And what about the defendant?
For James True and Herbert Swilley, it was in that inconclusive zone. So
I see. So
I could neither include or exclude them.
You couldn't rule them in, you couldn't rule them out.
Correct.
All right. Moving on to another adult toy, the swabs that you analyzed from the Satisfier. You had mentioned that that was a mixed DNA profile, correct me if I heard you wrong, that included that of the alleged victim, Tim Smith.
Yes.
And the defendant, Herbert Swilley.
Yes.
And James True.
That's correct.
Okay. And when you were asked what portions of the mixture were each of those gentlemen's, you had mentioned regarding James True, his DNA was 21% of the total mixture. Did I get that right?
I believe it was Timothy Smith that was the 21%.
Oh, I'm sorry. So James True was the 34%.
That's correct.
Understood. And was there any of your analysis of items that you tested for the presence of DNA that indicated a possible link to an individual named Lloyd Kelly?
Yes.
Okay. And what item or items was it that you tested that correlated to Lloyd Kelly?
That was the swab of the bottle caps of the lubricant bottles.
Okay. And that particular mixed DNA profile, what was the statistical probability that was Lloyd Kelly's DNA?
I did not make that calculation. I never obtained a sample from Lloyd Kelly to do that calculation.
Okay. So how were you able to identify identify the name Lloyd Kelly?
There was that particular sample was entered into the CODIS database, which CODIS stands for the Combined DNA Index System. The profile was entered in there, searched against the database, and returned a hit to somebody named Lloyd Kelly.
Okay. So meaning Lloyd Kelly's DNA was already within the database.
Correct.
So that's how you were able to make the link?
Yes.
Okay. Your Honor, may I have one moment with my colleague?
Yes.
Thank you.
Still with us, trial attorney Miguel Custodio. Miguel, all right, so cross-examination here, and what we're hearing about are other individuals. And we heard defense counsel say this in opening statements, saying the state would have you believe that they thoroughly investigated other people, and this is the guy. But defense counsel saying, no, they did not do a thorough investigation of these other people.
Yeah, and he's doing a good job. He's starting to mention other individuals' names, right? You keep hearing of James True. And even if the expert cannot say that the test came back with any of his DNA, at least he's dropping the name there, right? And that is meant to plant a seed in the jurors' minds, like, wait a minute, there's somebody else, there's other people. Did they really do a good job? And so he's doing a good job of planting that seed of doubt.
And we just heard also Lloyd Kelly. He was actually someone who testified via Zoom. He said he didn't know either the victim or the defendant. He recognized some pictures of a room. His DNA profile is something that they looked at. Now, they did go and interview these people. They did go and try and figure out what was their cell phone location at the time. Do they have an alibi? Is that enough? How far do you have to go down these rabbit trails when you may have potential other suspects, but you have so much more motive for this defendant?
Well, in this particular case, the motive is just, it's really there. Right? I mean, you have killing for a life insurance policy. We know that Smith was going to be leaving him. He was a breadwinner. So I think that there's quite a bit of a story there that the jury can go back in the deliberation room and say, of course he did it. Look why. Look, you know, look at the details, right? But I do think that it is important for the defense to really make it seem that the state did not follow through with their investigations, because of course they're going to have DNA of Swilly in Tim Smith, because that was his husband. Right. So I mean, I'm not really sure how many, how much they're scoring the state is in this case on that.
Miguel Custodio, thanks so much for joining us in studio. Always good to see you. We've got to get to a break. When we come back, though, the state's next witness is going to be on the stand, a crime lab analyst in the case against Herbert Swilly. He's going to testify about more DNA found at the crime scene. And you also see we still have the verdict watch clock going in that other Florida trial over the murder of 4-year-old Suni Bell. 13 hours as this jury hung. We'll keep you updated there. Welcome back to Court TV Live. I'm Julia Janae. Thank you for following along with us this afternoon as we are in Florida. A man is on trial for the death of his husband. His name is defendant Herbert Swilly. He's accused of drugging and then strangling Tim Smith, his husband, back in their home in 2023. And prosecutors say even though it happened in their marital home, that he then moved his husband's body to an apartment that the couple used for sexual encounters. They had an open marriage and they met with other people online. And they say that this defendant then staged the crime scene to happen there so he could point the finger at other people. And that's exactly what the defense is doing. They've said that there are other suspects who were not investigated properly. Let's get you back into court now. We just heard from a DNA analyst who talked about 2 foreign DNA profiles that were inside of that sex apartment. And now the state has called a crime lab analyst, Brooke Hoover, to the stand.
Would you please introduce yourself to the jury?
My name is Brooke Hoover, Hoover. I am a crime laboratory analyst at the Florida Department of Law Enforcement. I work in the biology and DNA section.
And what do you do there?
I analyze items of evidence for the presence of bodily fluids, most common blood, semen, saliva. I collect samples from items of evidence in order to determine who wore or who handled the item. I'll perform DNA testing on questioned items of evidence from crime scenes. I'll perform DNA testing on known reference standards from individuals, and I'll make comparisons between the two.
And how long have you been doing that job?
About 14 years.
Can you describe for the jury your educational background and training that allows you to do that job?
I have an Associate of Arts from St. John's River Community College, and I have a Bachelor of Science in Biology from the University of North Florida. While I was in college, I took courses in molecular and cellular biology, genetics, biochemistry, and statistics.
And have you gone through regular proficiency training and testing and things like that with Florida Department of Law Enforcement?
Yes, I completed their crime laboratory analyst training program. I completed FBI quality assurance training in order to be an auditor to audit other labs. I also undergo continuing education. I get at least 8 hours a year, and I have been current on that.
Have you testified in court and been permitted to give opinion testimony in the area of DNA analysis?
Yes, I have.
About how many times?
I believe this is about 110 times that I've testified.
Okay, Your Honor, at this time, may the witness be permitted to provide opinion testimony in the area of DNA analysis?
No objection of what there.
All right. I'll allow her to testify in the form of an opinion. Thank you.
We have already heard about what DNA is and the process that FDLE uses to analyze DNA, so I'm not going to waste time going over all that again. Were you provided several items of evidence in the case of State of Florida versus Herbert Swilly?
Yes, I was.
Did you perform DNA analysis on those items?
Yes, I did.
I'm showing you photograph 28 from States 5, where you provided sets of swabs collected from a dresser at an apartment.
Yes, I was.
Did you analyze those swabs for the presence of DNA? I'm showing you States Exhibit 22 and 23.
Yes, I did.
Okay, and what were your results?
Let's see,
They would be your agency items 45 and 46.
Okay.
That help?
Yes,
Okay.
so for both of these items, I took samples for DNA testing. They were extracted and quantitated, but quantitative PCR failed to demonstrate enough DNA for STR DNA analysis. Therefore, no further testing was conducted on these items.
Okay, you used a couple acronyms,
Sure.
STR and PCR. What are those
Yes,
things?
I'm sorry.
That's okay.
STR is short tandem repeat. It's the type of DNA testing we do. PCR stands for polymerase chain reaction. This is the genetic copy machine process. So we're making millions and millions of copies of the specific area of DNA that we are interested in. What happened with these items, we test a sample to see how much DNA is present. For both of these, there was not enough DNA that we would expect to get any DNA results.
And because of that, there's nothing else you can do to analyze the items, is there?
That's correct. We stopped processing at that point.
I'm showing you photograph 8 from States 18, where you also provided swabs taken from a tool chest handle.
Yes.
I'm showing you states 29. Did you analyze that item for the presence of DNA?
Yes, I did.
What were your results? Agency item 47.
Due to the limited nature of the DNA results obtained from this item, the results are not interpretable.
And is that different than the previous items you just described?
Yes.
How?
There was enough when we quantitated it that it was possible we could get usable DNA results. So we took the sample forward for DNA testing. When I did get the DNA results, I do not have enough to make any comparisons with anybody. I only have a little bit of information, and the danger with that is we could falsely include or falsely exclude an individual from such poor quality results. Therefore, we do not interpret it.
Yeah, I'm showing you photograph 4 from states 18. Did you receive 2 sets of swabs taken from the handles of a bedroom closet, specifically state items 32 and 33? Those are going to be your agency items 81 and 82, if that helps.
Yes. So one of the swabs, it was from the left door handle of northeast bedroom closet. From that swab, I did not obtain any DNA results at all. For the swab from the right door handle of northeast bedroom closet, it was extracted, quantitated. There was not enough to proceed with DNA testing. Therefore, nothing further was done with that item.
Now, on the one handle, you said there was no DNA found. Does that mean that no one has ever touched that doorknob in history?
No, that's not what that means. It's just no DNA was detected.
What is CODIS?
CODIS is the Combined DNA Index System. It is software that is owned by the FBI. It stores and it compares DNA profiles.
And are samples that are provided by law enforcement to Florida Department of Law Enforcement, consisting of victims, witnesses, suspects, things like that, routinely entered into that CODIS system?
Yes, per Florida state statute, when a sample qualifies for CODIS entry, we do enter it into the CODIS database.
And what happens, how does CODIS work with those samples that are entered into it?
The samples are developed by the laboratory. They go through a technical review, an administrative review, and then they're marked for upload. So at that point, they're uploaded to the state CODIS, and then if they qualify to national CODIS. There are routine searches that happen overnight with the CODIS system, and we are notified of any potential matches. So my role, I am the local CODIS administrator in Jacksonville. I manage the software, so I come in, I evaluate any potential associations with the CODIS software. If it is a match, I liaison with other law enforcement agencies in order to exchange casework information.
Okay. And you use the term potential match. Do you... Okay, never mind. Showing you photograph 9 from states 18. Did you, in your lab, receive some swabs collected from a lubrication bottle caps, showing you states 25?
Yes, we did receive those swabs.
Did you receive a potential CODIS DNA match from the DNA in those swabs?
Yes.
Okay, and explain what that resulted in, what that showed.
Yes, so there was a question DNA profile that resulted from the testing of the bottle caps of the lubricant bottles. It went into CODIS, and it hit to a convicted offender sample. So when that happens, I will issue a report to our investigating agency with the individual's name. So CODIS is an investigative lead only. It is up to the agency to collect a reference standard from that individual for us to test it. At that point, it's officially compared to the evidence. We'll issue a report addressing the association with any
was in the CODIS database because they're legally required to submit DNA if they've been put on probation or convicted of a felony. Then the CODIS system can examine those known DNA profiles to see if they match unknown samples?
Basically, yes, sir.
Okay. And what was discovered through the CODIS analysis of the item I just gave you, item states 18? I'm sorry, states 25.
It did hit to an offender sample.
Okay, and who?
Oh, the name,
Yes.
and again, this is an investigative lead. I'm not reporting a match. I'm just saying the investigative lead, we provided the name of Lloyd Kelly.
Was there a date of birth associated with that?
July 29th of 1973.
Okay, and you said it's an investigative lead, you're not reporting it was a match, but did you provide that investigative lead through the report to law enforcement agency or the state attorney's office or somebody?
Yes, we do issue that in a laboratory report, and it's provided to our submitting agency.
Okay. And in this case, were you provided a known sample from Lloyd Kelly to do a further follow-up comparison?
No, I was not.
Okay. No further questions, ma'am. Thank you.
Cross-examination, please.
Yes, Your Honor. Thank you. Good morning, ma'am.
Good morning.
You mentioned CODIS and that there was a convicted offender match to Lloyd Kelly regarding some of the items that you tested for the presence of DNA, correct?
Some of that's correct. I didn't perform the testing on that item. Lisa Johnson did, but I did issue the CODIS report.
Okay. So ideally, once you issue the CODIS report to the investigating law enforcement agency, you would want them to go and obtain a DNA swab from that convicted offender for comparison purposes, correct?
Yes.
Did that happen here?
It did not.
No further questions.
Anything else?
No, Your Honor. She may be released. Thank you.
You're released. Thank you.
All right, we had that crime lab analyst on the stand who isn't able to give the jury much that's definitive, but some things that the defense wants to hang their hat on in terms of other DNA profiles. When we come back, the prosecution is actually going to shift gears. They've been hearing, as far as the jury, a lot of technical information, and now there's going to be a friend of the defendant and victim on the stand. She's going to be asked how open these two were about their open marriage. Stay with us.
Young mother found brutally murdered.
Now the victim's boyfriend, a married father of 4,
is charged for the murder of his alleged mistress and her unborn child.
The Pregnant Mistress Murder Trial. Live coverage today, only on Court TV.
Tonight, on closing arguments, another dramatic day of testimony in the Pregnant Mistress Murder Trial. We'll break down the biggest moments in this death penalty case.
Closing arguments with Vinnie Politan tonight at 8/7 Central, only on Court TV.
Welcome back to Court TV Live. We are watching together Florida versus Herbert Swilley happening in Ocala, Florida, where a man was arrested for the 2023 murder of 59-year-old Timothy Smith. This was Herbert Swilley, the defendant's husband. The couple had been married nearly 8 years, and the victim was found dead in an apartment after failing to show up for work. The defense points to other suspects, but the prosecution says that this husband was strangled and dosed by his husband. Let's get you back into the courtroom now. We're listening to a friend of these two, the victim and the defendant. We've heard several friends who talked about a tumultuous relationship. Let's see what Candace Baker has to say.
Good afternoon.
Good afternoon.
I'm going to ask that you scoot up to that microphone and speak into that, please, so everybody can hear you the best you can. Thank you. Can you please tell the jury your name and spell your name?
Candace Baker, Candacebaker.
Thank you. Are you currently employed, Ms. Baker?
I am.
What do you do for a living?
I'm a sober coach.
What is a sober coach?
I assist people getting sober, finding new things to do, new ways to do them, getting to treatment.
Do you also own a commercial cleaning business?
I do.
How long have you owned that business?
Since approximately 2012.
And did you know Tim Smith?
I did.
Where did you meet Tim?
At an AA meeting.
And when did you meet Tim?
Around 2019.
And did you know Tim's husband, Herbert Swilley?
I did.
Do you see the person you know to be Herbert Swilley in the courtroom?
I do.
Can you point to him and describe something he's wearing?
Blue suit, striped tie.
Your Honor, may the record reflect the witness has identified the defendant?
It also reflects.
And when did you meet the defendant?
Maybe a few months after Tim.
Was that at AA also?
It was.
So Tim came to AA first and then the defendant?
Correct.
Were you and Tim close?
Very.
How often would you see Tim?
Maybe about 5-6 nights a week.
Did you do things socially with Tim other than AA?
Yes.
What kind of things did you and Tim do together?
We like to eat.
Okay. Did you do other things besides eat?
We did. We shopped. We like shoes. We did some road trips, lots of parties, dinners at his home, holiday events.
Were you also friends with Tim's husband, the defendant?
Sure.
Would you do some of those things with Tim and the defendant?
Absolutely.
And what kind of work did the defendant do?
He was a handyman.
All right. And what kind of work did Tim do?
He was a director in a retirement, I think it's called retirement place.
All right. And did you know Jordan Swilley?
I did.
And how was your relationship with Jordan?
She was like a daughter to me.
Were you aware that Tim and the defendant had an open marriage?
No.
Were you aware that they had sex with other people as a couple?
Yes.
All right. Were you aware that they had sex with other people separately?
No.
Were you aware of the apartment they had in addition to their marital home?
Yes.
Had you ever been there?
No, ma'am.
I want to direct your attention to March 24th of 2023, the day before they found Tim. On that date, did you learn that Tim was missing?
I did.
And how did you learn that?
I don't remember if it was a phone call or a text from Herbie asking if I'd seen or heard from Tim.
Do you remember around what time that was?
In the afternoon.
All right. And then did you actually speak with the defendant that afternoon, that Friday?
Yes.
Okay. And what did he say to you?
That Tim did not show up for work, which was not like Tim at all. I proceeded to call Tim and text and did not get a response.
All right. Did the defendant tell you anything else besides Tim didn't show up to work? Did he tell you where he thought Tim was?
No.
All right. So you reached out to Tim?
I did.
Did you get any response?
I did not.
Did the defendant say whether or not he and Tim were fighting?
He did not.
Now, did you ever speak to the defendant again that Friday evening after the initial call when you learned Tim was missing?
I don't think so.
Okay. Did you ever talk to the defendant about him finding Tim's Jeep at the apartment that Friday evening?
Oh, yeah, yes.
Tell the jury about that conversation. Did he call you or did you call him?
He called me, and the Jeep was over at the apartment, but nobody was entering the door. And there were no lights on. And I asked him to go in, and he said he didn't know where his key was.
Did he say he just didn't know where it was?
Yeah.
Okay, all right. And then what else did he tell you? Did you and he talk about guns at all?
Oh, that was after he went home.
Okay, so he called you?
We stayed on the phone. This was like a 2-hour phone call.
Okay.
And then in the process of that phone call, he starts saying, oh, well, he doesn't have any guns. And I said, well, why would he have guns? I thought you said he wasn't suicidal. And he said, well, I have the Glock, and I can hear him walking around the house as he's talking to me. So he's collecting guns as he's talking to me. And he says, okay, I have this gun. Okay, the only gun that's missing is the pink Glock, Tim's gun. So he goes into Jordan's room. He gets Jordan. He tells Jordan, you're coming with me.
And this is all Friday evening? You're
Friday
on the phone
night.
with him.
I'm on the phone with him.
Around what time was this?
This was late 9-ish.
Okay, all right.
Him and Jordan drive over to the apartment where the Jeep is.
Are you still on the phone with him?
I'm still on the phone.
All right.
He gets out of the car, of his truck, and goes into the Jeep. I'm still on the phone. I can hear, he gets the gun, he gets back in, he says, it's okay, I have the Glock. Tim doesn't have any guns.
So he was talking about a pink
Glock
gun that was Tim's. All right. He took the gun from the Jeep.
But this is also after the police did a wellness check, so I'm not understanding, if you're collecting guns, but you told the wellness check people that Tim is not suicidal, why are you now looking for guns?
Okay.
Why did you not say that when they were there?
So what happened after you're on the phone with him and he says, I got the pink Glock from the Jeep?
This witness is bringing back that personal side to this trial. You could hear the emotion in her voice. This was one of her good friends, the victim in this case. Let's bring in to discuss what we've seen so far. Criminal defense attorney Danny Rubin is with us. Danny, thanks so much for joining us. Let's talk about what this witness is able to share, because Candace has been able to not necessarily talk about any problems the way we've heard other witnesses talk about some major problems in this marriage and that it was deteriorating. But she says she wasn't even aware about the openness of their relationship, these other strangers that may have been involved with them. How does that help or hurt the defense case here?
I think when you bring in someone who knows the victim, you always want to try and humanize the person who's no longer with us. It endears that person to the jury. Whatever problems they may have had, whatever marital issues, whatever really humanizes the victim. Because that obviously not only endears the victim to the jury, but it makes the person a human being and not just a statistic.
Yeah, it seems like she, of course, was much closer to Tim than she was to the defendant here. But these people, mostly who are coming in, they knew both of them. Can you talk about the conflict sometimes for these witnesses coming to the stand and having to testify against one friend on behalf of getting justice for another?
Yeah, I mean, it's always, you always want to vet your witnesses beforehand. You always want to know what they're going to say. When you put on a witness that you believe is going to help you, you want that witness to actually help you in some way. And like I said before, going through the couple's relationship is a harrowing thing. I mean, you're talking about mental health issues, about openness of relationships. It really does provide some context for what was going on between the couple before the death.
Absolutely. It's important for a jury to hear. And we do understand, Danny, that actually the daughter who we've been hearing about, Jordan Swilley, daughter of the defendant, she is going to be taking the stand next. So we're going to squeeze in a break. Stand by, Danny. When we come back, we will get you back into the Swilley trial. Also want to bring your attention to the verdict watch we're on. You see the clock there, 13 hours and 44 minutes so far in the murder of Suni Bell case. This jury today, they had some questions about whether or not they needed to be unanimous on the charges. There are 5 men being tried together here with first-degree murder. There are some lessers like second-degree that the jury has wanted to know about, but this is all over the death of a 4-year-old little girl where the prosecution says they were hunted down. In terms of this little girl, her mother and her uncle, they survived. This morning, both sides discussed how to bring in principal defendant Zvante Sampson. Remember, he was escorted out of the courtroom Monday after an outburst. The state's closing argument did address it, and the judge decided that Sampson could FaceTime into the courtroom from a phone. When we get a verdict, or if the jury has another question, we'll take you into that courtroom. We'll be right back. Welcome back to Court TV Live. I'm Julia Janae. Thank you for being with us as we go back into an Ocala, Florida courtroom for the dosed and choked murder trial for Herbert Swilley. Prosecutors say that Swilley drugged and then strangled his husband, Tim Smith, all in order to receive a large life insurance payout. He even went on to GoFundMe immediately after the death to raise funds. The defense says, though, that Swilley and Smith had an open marriage and that the investigators overlooked other possible suspects. Let's get you back into a courtroom now. We're watching a friend of both the victim and defendant who is on the stand under direct examination.
So what happened after you're on the phone with him and he says, I got the pink Glock from the Jeep? Then what happens after that?
Then they drive home. We continue to talk for a few more minutes, then they go home.
All right. And Jordan, you said Jordan drove or she was with him?
They were together.
All right. All right. Did you speak to him again after that Friday night, the gun conversation?
I don't think so.
So I want to move on now to Saturday, the next day, March 25th of 2023. Did you contact the defendant that morning?
I tried to call him to see if he'd heard, did anybody find Tim? Where's Tim? He did not answer. I called Jordan. Did Tim come home? She said no.
Were you concerned at this point?
Yes.
Had you continued to try to reach Tim yourself?
I did.
And then what did you do after Jordan told you they hadn't heard from Tim?
I tried to call Tim.
Did you try to call the defendant again?
No, because I called him first.
Okay. Did you ever reach the defendant that morning and find out what happened to Tim?
He reached me.
Okay. So you would call to him, the defendant, he didn't answer, but then he reached out to you.
Mm-hmm. Correct.
Do you remember when that was?
I don't remember what time it was.
Okay. Do you remember if the morning or the afternoon?
Morning.
And when the defendant reached out to you, what did he say?
He's gone.
He's gone? Okay. Did he say anything else about how Tim had died?
He alluded suicide.
That's what you thought after your conversation?
And said he couldn't talk. Because I called him right away. When he texted me, he's gone. Of course, I have questions. What do you mean? Did he leave? Where'd he go? That's what I'm thinking. He left. I'm not thinking he's deceased. And he said I couldn't believe he would do this. That was the alluding to suicide. And he said he couldn't talk.
And then that was the end of the conversation?
That was the end of the conversation.
So you were left
thinking that he killed himself for hours that day.
Now, did you see the defendant at all that Saturday, the rest of that day?
No.
Okay. Did you learn at any time that day on Saturday that Tim hadn't died by suicide?
I think later I talked to him later on to see if him and Jordan ate. Did they need anything?
This is Saturday.
Saturday.
Mm-hmm.
And I think somebody else was bringing food to them, so they didn't need food. And then it wasn't suicide.
Did he say it was something else?
Said that he was murdered.
Were you surprised by that?
I was very surprised and had a lot of questions, but it was not to be talked about.
And did you ask questions and they weren't answered?
And it was not to be talked about.
Did he say that? What do you mean was not to be talked about? Explain that.
Yes. He's dead, he's gone. That's it.
All right. So you didn't learn anything else?
I did not.
All right. I want to move on now to the next day. We're at Sunday, the day after Tim's body was found, March 26th of 2023. Did you see the defendant that day?
I did.
All right. Where did you see him?
At their home.
Why did you go to the house?
To make sure they were all right.
Now,
see if they needed food. Okay. Called in the morning. See if they slept. Right. What I could do.
Now, when you arrived there, how was the defendant's demeanor?
like it was a regular day.
And right when you walked in, did you notice anything unusual when you walked in the front door?
As soon as he opened the door, I noticed the huge area rug was missing, and I said, "Where's the rug?" And he didn't answer me. And then we walked a few more steps into the kitchen area, and I noticed the area rug and the huge wooden coffee table was missing from the family room. And I said, where's the rug? Where's the coffee table? And then he said that the dog peed on it.
So two rugs were missing and a coffee table. And his explanation was the dog peed on it.
Yes, ma'am.
Your Honor, may I approach the witness?
Yes, ma'am.
I'm going to show you what's been marked for identification of States Exhibit EEE. I want you to look at that. And do you recognize that photograph?
Yes.
Does that photograph show one of the living room rugs that was missing when you came into the home?
Yes.
Okay. And where is that rug that was missing?
In the front living room when you walk in the home.
When you walk in the front door?
Correct.
All right. And is that a fair and accurate depiction of the way that rug looked at their home?
Yes.
Your Honor, at this time, we will move States Exhibit EEE into evidence.
No objection.
Objection EEE would be in evidence as number 56.
And who are the people in that picture? We were concentrating on the rug, but who are the people in the picture?
Tim and I.
And that's one of the rugs that was missing on Sunday in that photograph.
That's correct.
Your Honor, may I publish?
Sure.
All right. And is this right here the rug that we're talking about that was missing?
Yes.
Okay, what's on that rug? What is that?
It's a lobster. It's like the house is beach themed, so it had like different sea animals, and it was like a woven rug. So they would have been like kind of dug out white areas of different creatures, sea creatures.
And that's you and Tim?
Yes.
All right. Now I'm going to show you what's been entered in as States 31, photograph number 3. Where would that rug have been in this picture?
Underneath that round wooden and glass coffee table, all the way out probably to that bench, the left side, the window, and out to that chair, and all the way to the left window.
And is this right here the front door where you walk in?
Mm-hmm.
Okay, so you
Yes,
walked in, and this is what you saw, this empty, that rug missing.
Correct.
All right.
His friend's spidey senses are going off. She thinks it's strange that this huge rug is missing. Also that this defendant simply said he's gone and suggested this was a suicide rather than a murder. Let's get to a break. When we come back, more of this friend on the stand who is detailing it all for this jury.
Saturday nights on ION is our night. Let's go! Double headers every Saturday at 7 and 10 p.m. Eastern. The new Saturday Night Out is on ION all season long.
Tonight, on Closing Arguments, another dramatic day of testimony in the pregnant mistress murder trial. We'll break down the biggest moments in this death penalty case.
Closing Arguments with Vinny Politan tonight at 8, 7 Central, only on Court TV.
defendant in this case lie about his husband dying of suicide, or was he just a deeply distraught spouse? Herbert Swilley is accused of murdering his husband of nearly 10 years, Tim Smith. Prosecutors say the marriage was on the rocks and Smith was planning to leave Swilley. They say Swilley couldn't afford to keep up his lifestyle without his husband's income, and he wanted to cash in on a $300,000 plus life insurance after his death. We are hearing the play-by-play of what happened following the discovery of Tim Smith's body through the eyes of a friend, Crystal Baker. She said that she noticed that Swilley was quickly trying to throw out all of his husband's belongings.
Now, after you noticed that that was missing, and then as well as another rug and table, who else was there?
It was just Jordan and Herb.
Okay. And what else was happening?
And I sat down and I noticed what they were doing. They had the garbage cans from outside, inside the house, two garbage cans. Jordan had one in the kitchen, Herb had one in the pantry, and they were knocking off things off the counter into the garbage cans and off the shelves in the pantry. And
What sort of things?
Tim's vitamins, and he drank protein drinks and gummies and different vitamins. He did this regiment. So he had like 20, 15, just tons of different drinks and snacks and rice cakes, and they were just throwing away anything that was on the counter, the mixing cups. And I started looking around, and the portraits, family portraits, were off the wall. And I looked around, and all the candles and the seashells and the mermaids and all the knickknacks were gone, and they were in the dumpsters, and they were stacked up. The pictures were stacked up, and Jordan looked over at me, and she said,
Object to hearsay.
Sustained.
You can't tell us what anybody said. Now, when you're saying all these knickknacks and everything, whose knickknacks were these?
They were Tim's.
So everything was getting thrown away?
Everything of Tim's was all going in the dumpster.
And the pictures that you're talking about, they were framed pictures that used to hang on the wall?
Yes.
Were they professional?
Professional family photos, photos of Jordan growing up from the time they, had been together.
And Tim was in these photographs?
And Tim was in the photographs. They were professional photos of the two of them, marital photos.
And did the defendant indicate that he was going to throw those away?
Yes.
All right. Did he
Photo
say
albums, everything.
all of Tim's?
Yes.
Did the defendant say why he was doing that?
It's his house now, and he's finally going to get the house that he always wanted.
Now, when is the last time you had been at their house and seen that rug and those coffee tables there?
I would say 2 weeks, 2 to 3 weeks prior. Tim and I went somewhere together.
All right. Did you ever go to their house around that time to get some blow-up mattresses?
I went to pick up an air mattress for my grandkids. I have too many grandkids, and I needed to borrow another air mattress.
Were they coming to visit you?
They were.
For what?
For spring break.
Spring break, okay. So it had been 2 to 3 weeks you had been there and seen that rug there?
Correct.
Now, while you were there that Sunday after they found Tim, did the defendant say anything about insurance money?
That's what they were going to do next.
What does that mean? What did he say?
When he said that he was getting the house that he always wanted by getting rid of all of that stuff, the next thing he was going to do was get in that office and get those papers to get to his money.
To get to those papers, did he say insurance papers?
My money, to get my money. He needed to find the insurance papers.
So did he specifically say, I need to find insurance papers?
Yes.
Okay, to get my money?
My money, yes.
About how long were you at the house that Sunday?
I would say about 30 minutes. I was screaming inside to stop touching Tim's things. I really couldn't understand what was going on.
So you left.
All right.
Now, did you talk to the defendant the next evening, which would have been Monday, March 27th of 2023, 2 days after Tim had been found? All right.
Yes.
Did you talk to him on the phone or did you see him in person?
On the phone.
Around what time was that?
We talked several times a day.
All right.
So
Did you talk to him at some point during that Monday where he was at an AutoZone?
yes.
Okay.
So that would have been 8:30ish at night.
All right.
He was blowing my phone up while I was in a meeting, and when I came out, I'd missed a lot of calls from him.
How did you know he was at AutoZone?
I asked him where he was because it didn't, you can tell I'm like, where are you? And he said, I'm at AutoZone. And
Was he by himself?
He was with Jordan.
And did he tell you what they were doing at AutoZone?
Yes, he did.
What did he say they were doing?
He said that he was getting cleaners to clean the Jeep because the police wanted the Jeep back.
He was getting cleaners to clean the Jeep because the police wanted it. All right. Did he say anything about fingerprints being in the Jeep? People's fingerprints? What did he say?
He said that, Candy, I have to clean the Jeep. You've been in the Jeep. I have to get your fingerprints out. And I said, I wouldn't hurt anyone. I don't care if my fingerprints are in the Jeep. And he said that a lot of our friends have been in that Jeep, and I have to get that Jeep cleaned before the police get it.
Now, on March 29th of 2023, which would be about 3 days after you were at the defendant's house, did you call the Marion County Sheriff's Office and speak with the detective?
I did.
All right. Did you tell him everything you knew that you told us?
I did.
Thank you. I don't have any other questions, Judge.
Cross-examination, please.
Yes, Your Honor. Thank you. Good afternoon, Ms. Baker.
Good afternoon.
After March 29th of 2023, did you cut off ties with Herbert, or did you continue to speak with him?
I don't know what date March 29th is.
Sure, that was the date that you contacted the Marion County
I did
Sheriff's
cut off ties.
Okay.
All right, we're hitting the pause button on this testimony. We're getting close to the top of the hour, and I've got to get reaction from criminal defense attorney Danny Rubin. Danny, she is saying that this defendant said, I get the house I always wanted, that he was throwing away wedding photos not too long after this murder and cleaning fingerprints off of the car. I mean, what's standing out to you is the words that she's a gift to the prosecution in terms of what she says she heard.
Again, this is the prosecution's direct. So I'm sure her testimony has been, first of all, solicited, and second of all, she's probably, had some sort of dealings with the prosecutor to make sure that she's giving the kind of testimony that's benefiting the prosecution. All these things obviously are problematic. Not seeing the rug is an issue. The fingerprints, or dusting off fingerprints of the cars, is potentially problematic. But we should wait to see what happens on cross-examination. Right now, there's nothing that is going to be adverse to what she's saying, but it's the defense's turn next to pick apart all these details.
This is true. We don't want to discount the defense's side of this, Danny. I also want to ask you if you can help our viewers understand, because often we don't get these kind of revelations from after something happens. Most people just go radio silent and don't talk about a lot of things. But why is it that she's able to say what he said? A lot of people know hearsay is when these witnesses get on the stand and they get stopped from saying what someone else said. But this is different.
There are certain exceptions to the hearsay rule. I know it's the hard and fast rule is any out-of-court statement made for the truth of the matter asserted is not allowed to come in. But here, we're talking about excited utterances, things that happened at the scene, some declarations against interest. Whenever someone says something that's against their own personal interest, those things can come in as exceptions to hearsay. So some of the things that she was talking about would fit some of those hearsay exceptions.
Absolutely, and he is on trial, so all of this is at issue, what he would say. Danny Rubin, thank you so much for joining us and lending us your expertise. We're going to get everyone back inside of the courtroom on the other side of this break, we'll not only hear the rest of that cross-examination, one Danny wants to make sure you pay attention to see what's adverse to this witness, but also the defendant's daughter. You've been hearing about her, Jordan Swilly. She was there living in the home with her father and his husband. She is going to be taking the stand. You don't want to miss it. Stay with us. You're watching Court TV, your front row seat to justice.
Welcome back to Court TV Live. I'm Judge Ashley Wilcott, of course, honored to be with you today. Let's turn now back to Florida, where the defendant, Herbert Swilley, is accused of murdering his own husband, Timothy Smith. Prosecutors say the marriage was on the rocks, and Smith was planning to leave Swilley. They say Swilley could not afford to keep up his lifestyle without his husband's income, and he wanted to cash in on Smith's life insurance after his death. Let's go back into the courtroom together. On the stand is a friend of the couple, Candace Baker. She's on direct examination by the state.
And at one point in time, prior to Tim Smith's death, you were cleaning their marital home, were you not?
For a short time.
Okay. And that ended in the latter part of 2022, correct?
I'm not sure. It was just maybe 3 months I did that. I'm not sure of the dates.
Okay. But not at all in the year that Tim Smith died?
No, sir.
Okay. And you mentioned having come to the marital home 2 to 3 weeks prior to Tim Smith being discovered dead and picking up air mattresses?
An air mattress.
Okay. Did you stay there for any length of time when you were doing that, or was it kind of a quick in and out?
No, sat at the counter, maybe 20 minutes or so, chit-chatted.
The counter in the kitchen?
Yes, sir.
Okay. And you mentioned that the rug that you identified from the pictures was still there.
Both rugs and the coffee table.
Okay. And the coffee table that you claim was not there when you went on March 26th, the year that Tim died. What was that coffee table?
A wooden coffee table, very heavy wood coffee table.
Okay. And you mentioned that you were very close to Tim Smith, correct?
Yes.
But you did not know that Tim Smith was in an open relationship, right?
No.
Okay. And in addition to raising your suspicions about Herbert's conduct after Tim's death, did you also tell the sheriff's office to look into other persons who may have been involved in Tim Smith's murder?
No.
You didn't mention to them looking into a terminated employee from Brookdale?
No.
Okay. You mentioned knowing about the apartment that Tim Smith had leased, right?
Correct.
Oh. And how long before Tim Smith's death did you learn of the use of that apartment by Tim Smith?
I don't understand the question.
How long had you known Tim Smith to have the apartment before his death? Weeks,
When
months?
they got it. When they got it and were working on it.
Okay, that was when you learned of the existence of the apartment. Mm-hmm. So yes?
Yes.
Okay. Did you know anything about Tim Smith looking for other work?
No. No.
Okay. Your Honor, may I have a moment with my colleague?
Yes, sir.
Thank you.
Your Honor, I have no further questions. Thank you. She excused?
We ask that she be excused, Your Honor.
Have a nice day, ma'am. Thank you very much.
Thank you.
The state calls Lacey Larimore.
Well, this little witness sure was credible, just telling what she knew. She knew both of them, the victim and the defendant. One of the things that stood out to me is, you know, she said things like the defendant in the case was cleaning his car because the police wanted it back, and the defendant was putting photos away in the house, things that belonged to the victim in this case, and packing them all up. Things that certainly make it sound like the defendant's guilty. Whether or not the jury's going to find that, we're going to have to wait and see. I understand that the next witness up is Jordan Swilly. Now, this is the defendant's daughter. Remember, this is part of the state's case. Let's go back in.
Ma'am, hold on a second. Stand up. Raise your right hand. Face the clerk over here. Thank you.
Swear or affirm testimony about to give you the truth, the whole truth, and nothing but the truth, so help you God. Yes, I swear.
Now you can have a seat. Thank you. Go ahead.
Thank you. Good afternoon.
Hello.
I just need to make sure that you speak up so everybody can hear you and talk into the microphone. Can you tell the jury your name?
Jordan Swilly.
How old are you, Jordan?
22.
Where do you currently live?
The Darley Apartments.
Is that in Ocala?
Yes.
With whom do you live?
My boyfriend.
Okay, what's his name?
Mick.
Mick?
Mick.
Before Mick, did you live with a girl named Layla Lopez?
Yes.
And what was your relationship with Layla?
She was my best friend.
How long have you been friends?
About 5 years.
Was Layla your best friend at the time that Tim was murdered?
Yes.
Are you employed?
Yes.
Where do you work?
Red Sauce.
What's Red Sauce?
It's a restaurant.
What do you do there?
I'm a server.
Is the defendant Herbert Swilly your biological father?
Yes.
And you knew Tim Smith?
Yeah.
How did you know Tim?
He was my stepdad.
Were you and Tim close?
Yeah.
Was he like a second father to you?
Yes.
And what's your mother's name?
Angela.
Okay. What's her last name?
Will.
Was the defendant and your mother married?
Yes.
About how long were they married?
I think like 13 or more years.
Did you live with your mom and the defendant when you were young?
Yes.
Where did you live?
It was like Waldo, Gainesville area.
Are you their only child?
Yes.
Before they became romantically involved, were your dad and Tim friends?
Yes.
How long had you known Tim before he died?
Quite a long time. I think this has been a lot of years.
Were you a young child when you first met Tim?
Yes, I was around like 4.
All right. And did Tim and your dad become romantically involved, which caused the defendant to leave your mom?
Yes.
All right. And approximately how old were you when that happened?
I believe around 8.
And did you continue to live with your mom when your dad left her?
Yes.
At some point, did you move in with Tim and your dad?
Yes.
And how old were you when that happened?
I was in middle school, so about like 15 or 14.
All right. Did you move to the house at 5? How many bedrooms did that house have?
4.
How many bathrooms did it have?
3.
Do you know approximately how big it was?
I'm not sure. It was a big house.
It was a big house? And what did your dad do for a living?
He did a handyman service.
How long had he been doing that type of work?
Like 3 or so years.
And what did Tim do for a living?
He was an administrator at a nursing home.
Administrator at a nursing home? Right. And did the house that you live in have cameras?
Yes.
And was there a computer in the house?
Yeah.
Okay. Where were the cameras?
Outside.
Okay. Where were they outside?
On the front door and out on the side of the house.
What did the camera on the outside of the house face? What area?
The front one was the front of the property, and then the side was like the garage and everything.
Okay. Was it a Ring? Do you know if it was a Ring doorbell camera
Yes.
system? Did you have that Ring app on your phone?
Yes.
Would you get an alert on your phone if the camera was activated?
Yes.
Now, did you work at Laredo's restaurant before Tim died?
Yes.
How long did you work there?
It was on and off for like a few years.
Were you working there when Tim was murdered?
No.
Where were you working?
The Murphy's gas station.
How long had you been working at the Murphy's gas station?
Only a few months.
And how old were you when Tim died?
19.
Did Tim and your dad drink alcohol for the majority of their relationship?
Yes.
Would you say they both were heavy drinkers?
Yes.
At some point, did they both stop drinking and become members of Alcoholics Anonymous?
Yes.
Did their relationship change when they both stopped drinking?
Yes.
How did it change?
It just became different, like more arguing.
More arguing when the drinking stopped? And how were they getting along when Tim died?
Just like not very well, like they were bickering a lot.
Now, in the months leading up to Tim's murder, did you become increasingly upset or frustrated with how much they were arguing?
Yes.
Okay. Would you often go to work at Laredo's early just to get away from the arguing?
Yes.
Did the defendant ever mention something to you about a divorce with Tim due to complications in the relationship?
Yes, I believe so.
Yes. Okay. Had Tim become more...
You know, it's always interesting when the prosecution calls family members related to the defendant. This is his own daughter. We're going to take a break here. When we come back, we're going to bring you more of her testimony in the dosed and choked murder trial of Herbert Swilly. Stay tuned.
My two best friends were just murdered.
Join me for a Court TV true crime series where we take you from the crime scene to the courtroom.
Donna Adelson hates every piece of grass that Dan Marcel ever walked on.
It's something that'll haunt all of us forever.
It always seemed like he was covering or deceiving.
This was a whole different level.
Victim to Verdict with Ted Rowlands, a Court TV original series. Season premieres September 27th.
Only on Court TV.
Welcome back. We are tracking several other cases today here at Court TV. All of the cases are out of Florida. First in Tampa, a jury has been deliberating now. You can see your clock on the screen, 14 hours and 33 minutes, a long time, in the murder of Suni Bell case. 5 men are all charged in the drive-by shooting of the 4-year-old little girl. Of course, we will take you there live as soon as we have a verdict. In Fort Pierce, testimony ended earlier today in the murder trial for Jose Soto Escalera, the married father accused of killing 23-year-old Tanya Wise after she allegedly refused to get rid of the baby that they had conceived. The state plans to call one more witness tomorrow before resting their case in chief. And for now, we are bringing you testimony out of Ocala, where the dosed and choked murder trial remains underway. Prosecutors claim that defendant Herbert Swilley drugged and strangled his husband and then staged a fake crime scene. Let's go back inside court together now. We're listening to testimony from Swilley's own daughter, Jordan. This is direct examination of the state.
Had Tim become more secretive in the months leading up to the murder?
Yes.
How so?
He just wouldn't talk about a lot of stuff.
Right. Were you aware that Tim was interviewing for a new job in DeLand?
No.
Your dad never told you about that Tim was interviewing for a new job?
It wasn't until like later on, I don't think.
Okay. At some point, your dad told you that?
It was at some point.
All right. You're just not sure when?
Yeah, I'm not sure when.
Did you and your dad plan on moving with Tim if he got the new job in DeLand?
No.
Did your dad tell you why?
He just didn't want to move again.
All right. Was Tim the breadwinner in the family?
Yes, kinda.
All right. Could you and your dad afford to live in the house without Tim's salary?
Possibly not. Not sure, like 100%.
Do you remember when you testified in front of the grand jury in November of 2023?
Yes.
Okay. Do you remember being asked if you and your dad could afford to live in the house without Tim's salary and saying no?
Yes.
Okay. Now, did your dad work out?
Yes.
Okay. How many times a week?
Probably like 4 or so.
All right. Where did he work out?
Planet Fitness.
Was your dad physically fit?
Yes.
Did Tim have a nighttime ritual of taking medications or vitamins every night?
Yes.
All right. Do you know what kind of medications he took?
Not sure.
All right. Now, before Tim was murdered, were you aware that the defendant and Tim had an apartment they used for sexual activities?
I found out later.
Okay. So you didn't know beforehand?
Yeah, I just knew about it, but it was a massage parlor.
Okay. So your understanding was they had an apartment, it was a massage?
Yes.
Okay. Were you aware that they were in an open relationship?
No.
Had you ever been to that apartment before Tim went missing?
No.
Now, I want to talk about Thursday, March 23rd of 2023, and that's the Thursday before Tim's body was found. Okay. Did anything unusual happen that morning or that afternoon before you came home?
I don't believe so, no.
All right. Now, when you got home that evening, who was there? This is the
I
Thursday.
think both of them were.
Your dad and Tim?
Yes.
All right, and you?
Thursday, yes.
All right. Did you, Tim, and your dad eat dinner together that Thursday?
Yes.
And what did you guys do after you had dinner?
We watched a movie.
Where did you watch a movie?
In the living room.
And then after the movie, what did you do?
I went to my room.
All right.
Just watched TV.
Okay.
Hold on one second. Andy, speak up just a little bit, okay?
Yes. And around what time was that?
Probably like 9.
Okay. And is that the last time you saw Tim, that 9 o'clock Thursday?
Yes.
And did Tim seem like he was under the influence of any drugs or alcohol at that time when you went into your room when you last saw him?
No.
Was he acting normally?
Yes.
Okay. Could he walk and talk?
Yes.
And what was he wearing when you went in your room?
Just like normal pajamas.
Was he getting ready to go to bed also?
Yeah.
And were your dad and Tim arguing during this time that you saw?
No.
Were you aware that Tim had a job interview the next morning?
No.
And what time did you actually go to bed that night?
Probably like later at night, like 10, 11.
Now, did you hear anything suspicious after you went to bed?
I believe I heard some noise.
You heard some noise, all right. And do you know what time that was?
I'm not exactly sure.
Okay. And do you know what the noise was?
No.
Did that wake you up?
A little bit, yes.
And after you went to sleep that Thursday night, did you get any notifications of movement on your cell phone from that Ring doorbell application?
I believe so, yes.
All right. Do you remember what time that was?
I'm not exactly sure, don't remember.
Do you know if it was after you heard the noise?
I believe so, yes.
All right. So you heard the noise, and then sometime later, your Ring doorbell application was going off?
Yes.
Did it go off several times?
Not sure. I can't remember exactly.
Did you look at your phone to see why you were getting notifications from the Ring doorbell?
I believe so, yeah.
Okay. You looked at it?
I remember like just seeing the notifications.
Okay. Did you see what was causing the movement,
No.
or the notifications?
No.
All right. Now, the next morning, that Friday, what time did you wake up?
Probably like 9, I think. I'm not sure exactly.
All right. And who was at the house when you woke up?
My dad.
Did you ask your dad where Tim was?
Yes.
Okay. What did he say?
I think he had said he was at work or something already. I don't remember exactly.
Okay. He said he was at work?
Hold on. I believe one of the jurors couldn't hear you. Can you repeat your last answer?
I think he had said he was at work, but I'm not exactly sure. I can't remember that day that very well.
Did your dad ask you if you heard anything that night?
Yes.
Okay. And what did you say when your dad asked you if you heard anything that night?
I told him yes, I had.
All right. Did you tell him what you heard?
I can't really remember exactly what I said to him.
Okay. You told him you heard something?
Yeah.
Okay. And what did he say when you told him you heard something?
Trying to remember. Sorry.
It's okay.
I think it was just something along the lines that saying to me that I hadn't heard it or something.
Okay. Would it refresh your recollection to look at your grand jury testimony?
Yes.
Hold on one second. You're talking too low, so some of the jurors can't hear you. Can you repeat that last
Yes,
question
Your
and
Honor.
answer it again? Thank you.
All right. And what did your dad say to you when you told him you heard some noise?
He had said something, I can't remember like exactly along the lines of that I hadn't heard it or.
Would it refresh your recollection to look at your grand jury testimony as to what your dad said when you told him you heard it?
Yes.
All right. And for the record, I'm going to refer defense to the grand jury testimony November 14th of 2023, page 35, line 2. Your Honor, may I approach?
Sure.
And just read this to yourself. This is page.
And that's how you have to refresh recollection. They have to read it to themselves. They can't testify from that. So while that's happening, I want to bring in trial attorney Gabriel Sepulveda Sanchez in the studio with us, and former LA County Deputy Public Defender Philip Dubay. Gabriel, thank you so much for being here in person. We're watching this together, and I think pretty bad testimony for the defendant when the daughter's saying, I told my dad I heard something.
Definitely. I mean, there's a lot of the testimony that came out. There's some evidence of motive. She talked about the victim being the breadwinner of the family, them having fights a lot, the arguing getting worse after they stopped drinking. But then that testimony right now where she said that I told my dad I heard something in the middle of the night, and then the defendant says you didn't hear anything. So it's circumstantial, but there's evidence, there's some motive there. They got some good evidence of motive to what the reason was for killing the victim, and also circumstances showing that this sounds very odd that you're telling your daughter, no, you didn't hear anything, you're just imagining something. So it's not a good witness for the defendant right now.
I would agree with you, and we haven't heard any testimony suggesting, and the defense doesn't have to put on a case, but we haven't yet heard any testimony suggesting anybody else was home with them that could have been heard. And so I think they've kind of narrowed it down to say she heard something and this defendant was the one there with her.
Definitely, yeah, exactly. I agree. That was definitely a good testimony for the prosecution.
I would agree with you. All right, weigh in. Philip Dubay, great to see you. Thanks again for being on with us. What are your thoughts as you're watching this unfold, especially the primacy recency part of the witnesses being at the end that are like this one, the daughter?
Well, I don't think it's enough. You know, it would be one thing if she said, you know, I think I saw Tim prowling around a window outside, or I heard him yelling upstairs saying, I'm going to kill that SOB. But if all you do is hear a noise, I mean, that could be a squirrel on the roof, it could be a raccoon, it could be a coyote out back. It means nothing. I mean, it's just, in my opinion, it's just too amorphous to say that it had to be Tim. It's just not enough there. I'm sorry, or Herbert.
All right, I'll be curious to hear what else she testifies to after she's refreshed her recollection by looking at her own grand jury testimony. Let's do this. We are going to take a break. When we come back, we'll have more testimony from the defendant's daughter in the dosed and choked murder trial. Stay tuned. Welcome back to Court TV Live. I'm Ashley Wilcott. Thank you so much for being with us today. Now, let's head back to Florida for the dosed and choked murder trial for Herbert Swilley. Prosecutors say that Swilley drugged and then strangled his husband, Tim Smith, in order to receive a large life insurance payout. The defense, though, says Swilley and Smith had an open marriage and that investigators overlooked other possible suspects. Let's get you back into court now. When we left off, we're going back in with the defendant's daughter, and she had just testified that her father told her to say she was sleeping and that she did not
All right. Bring him in when he's gone. All rise for the jurors. He's back. You all may be seated. Thank you. All right, ladies and gentlemen, my understanding is that you all have reached a verdict? Yes, sir. And you are the foreman, sir? Yes, sir. If you could hand that verdict form to one of the deputies. Thank you, sir. Yes. Madam Clerk, if you would publish the verdict form.
State of Florida versus Quandarious Hammond, Zvante Sampson, Jaylin Bedward, Andrew Thompson, and James Denson. Verdict form: we the jury find as follows as to count one of the indictment as to Quandarious Hammond. The defendant is guilty of the first-degree premeditated murder of Suni Bell, as charged. And did the defendant personally carry, display, use, threaten, or attempt to use a firearm? Yes. Did the defendant actually possess a firearm? Yes. Did the defendant discharge a firearm? Yes. We the jury find as follows as to count one of the indictment as to Zvante Sampson. The defendant is guilty of first-degree premeditated murder of Suni Bell, as charged. We the jury find as follows as to count one of the indictment as to Jaylin Bedward. The defendant is guilty of the first-degree premeditated murder of Suni Bell, as charged. We the jury find as follows as to count one of the indictment as to Andrew Thompson. The defendant is guilty of the first-degree premeditated murder of Suni Bell, as charged. And did the defendant personally carry, display, use, threaten, or attempt to use a firearm? Yes. Did the defendant actually possess a firearm? Yes. Did the defendant discharge a firearm? Yes. We the jury find as follows as to count one of the indictment as to James Denson. The defendant is guilty of the first-degree premeditated murder, as charged. And did the defendant personally carry, display, use, threaten, or attempt to use a firearm? Yes. Did the defendant actually possess a firearm? Yes. Did the defendant discharge a firearm? Yes. Count two, we the jury find as follows as to count two of the indictment as to Quandarious Hammond. The defendant is guilty of the attempted first-degree murder of Mary Harrison, as charged. And did the defendant personally carry, display, use, threaten, or attempt to use a firearm? Yes. Did the defendant actually possess a firearm? Yes. Did the defendant discharge a firearm? Yes. We the jury find as follows as to count two of the indictment as to Zvante Sampson. The defendant is guilty of attempted first-degree murder of Mary Harrison, as charged. We, the jury, find as follows as to count 2 of the indictment as to Jaylin Bedward. The defendant is guilty of the attempted first-degree murder of Mary Harrison as charged. We, the jury, find as follows as to count 2 of the indictment as to Andrew Thompson. The defendant is guilty of the attempted first-degree murder of Mary Harrison. And did the defendant personally carry, display, use, threaten, or attempt to use a firearm? Yes. Did the defendant actually possess a firearm? Yes. Did the defendant discharge a firearm? Yes. We, the jury, find as follows as to count 2 of the indictment as to James Denson. The defendant is guilty of the attempted first-degree murder of Mary Harrison as charged. And did the defendant personally carry, display, use, threaten, or attempt to use a firearm? Yes. Did the defendant actually possess a firearm? Yes. Did the defendant discharge a firearm? Yes. Count 3, we, the jury, find as follows as to count 3 of the indictment as to Quandarious Hammond. The defendant is guilty of attempted first-degree murder of Willie Brown as charged. And did the defendant personally carry, display, use, threaten, or attempt to use a firearm? Yes. Did the defendant actually possess a firearm? Yes. Did the defendant discharge a firearm? Yes. We, the jury, find as follows as to count 3 of the indictment as to Zvante Sampson. The defendant is guilty of the attempted first-degree premeditated murder of Willie Brown as charged. Count 4, we, the jury, find as follows as to count 4 of the indictment as to Quandarious Hammond. The defendant is guilty of conspiracy to commit first-degree murder as charged. We, the jury, find as follows as to count 4 of the indictment as to Zvante Sampson. The defendant is guilty of conspiracy to commit first-degree murder as charged. We, the jury, find as follows as to count 4 of the indictment as to Jaylin Bedward. The defendant is guilty of conspiracy to commit first-degree murder as charged. We, the jury, find as follows as to count 4 of the indictment as to Andrew Thompson. The defendant is guilty of conspiracy to commit first-degree murder as charged. We, the jury, find as follows as to count 4 of the indictment as to James Denson. The defendant is guilty of conspiracy to commit first-degree murder as charged. Count 5, we, the jury, find as follows as to count 5 of the indictment as to Quandarious Hammond. The defendant is guilty of shooting at, within, or into a vehicle as charged. We, the jury, find as follows as to count 5 of the indictment as to Zvante Sampson. The defendant is guilty of shooting at, within, or into a vehicle as charged. We, the jury, find as follows as to count 5 of the indictment as to Jaylin Bedward. The defendant is guilty of shooting at, within, or into a vehicle as charged. We, the jury, find as follows as to count 5 of the indictment as to Andrew Thompson. The defendant is guilty of shooting at, within, or into a vehicle as charged. We, the jury, find as follows as to count 5 of the indictment as to James Denson. The defendant is guilty of shooting at, within, or into a vehicle as charged. Count 6, we, the jury, find as follows as to count 6 of the indictment as to Quandarious Hammond. The defendant is guilty of discharge of a firearm from a vehicle as charged. We, the jury, find as follows as to count 6 of the indictment as to Andrew Thompson. The defendant is guilty of discharge of a firearm from a vehicle as charged. We, the jury, find as follows as to count 6 of the indictment as to James Denson. The defendant is guilty of discharge of a firearm from a vehicle as charged. So say we all, dated this 17th day of September 2025, signed foreperson of the jury.
Would the attorneys like the jury polled?
Yes, Your Honor. Yes, Your Honor.
Yes, Your Honor. Madam Clerk?
Juror number 1, is this your true and correct verdict?
Yes.
Juror number 2, is this your true and correct verdict?
Yes.
Juror number 3, is this your true and correct verdict?
Yes.
Juror number 4, is this your true and correct verdict?
Yes.
Juror number 5, is this your true and correct verdict?
Yes.
Juror number 6, is this your true and correct verdict?
Yes.
Juror number 7, is this your true and correct verdict?
Yes.
Juror number 8, is this your true and correct verdict? Juror number 9, is this your true and correct verdict?
Yes.
Juror number 10, is this your true and correct verdict? Yes. Juror number 11, is this your true and correct verdict? Yes. Juror number 12, is this your true and correct verdict? Yes. Thank you.
All right, ladies and gentlemen of the jury, I wish to thank you for your time and consideration of this case. I also wish to advise you of some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room except by a court order. For many centuries, our society has relied upon juries for the consideration of very serious and difficult cases, and we have recognized for hundreds of years that a jury's deliberations and discussions and votes should remain their private affair so long as they shall wish it. Therefore, the law gives you the unique privilege not to speak about the jury's work. Although you are at liberty to speak with anyone you would like to about your work and your deliberations, you are also at liberty to refuse to speak to anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious. It could come from those who might seem to find fault with your decision, from the media, from the attorneys, or elsewhere. It will be up to you to decide whether to preserve your privacy as a jury. And with that, I now release you from your services in this case with a thank you.
All rise for the verdict.
Jury select, all may be seated. All right, is there any consensus on when you would like to have sentencing, if not today?
Your Honor, Mr. Denson is entitled to a pre-sentence investigation because he has no prior felony convictions. I would request that the court order them.
All right, we can do that, even though he's entitled to a pre-sentence investigation. Count one carries a mandatory life imprisonment.
Understood.
So, for the sake of housekeeping then, I would just carry everyone along to that same day so that we can get the score sheets together. The points on the score sheet are going to matter as to how I fashion my sentence in this case, even though count one is a mandatory life. On say, let's see, October 27 at 8:30 for sentencing on all 5 defendants, unless there's a major conflict with some or more of the attorneys.
That's fine for me.
All right?
That's fine, sir.
All right, October 27, 8:30 in the morning for sentencing. They'll be remanded to the custody of the Hillsborough County Jail. I will adjudicate them all guilty on all accounts, and they will be held without bond.
Court stands in recess. Please exit.
Make sure we have our lobby.
My client is younger than Mr. Denson. He may be entitled to
He's entitled to a pre-sentence investigation, but he has no prior record. Does he have any prior felony record?
Pardon?
Does he have any prior felonies? Well, if he doesn't, I mean, anyone is entitled to a pre-sentence investigation.
I would ask you to order that.
All right. And so your client and Mr. Fichetti's client?
Mr. Bedward.
Mr. Bedward and Mr. Denson. The court will be in recess.
Oh, let me grab a second.